probably 94025.
Yes, Mr. Sir. Playing for? Password. Are you ready? No problem. Can you wait?
It will have to be details your document and be given to mention.
Very good. Well. First.
Item 2, WPC 785226.
Make use of the mic. Please make use of the mic. Those who speak louder, we may grant entry orders also. Those who do not, we may dismiss also. Because it's a torture.
I am now speaking.
Yes.
My options notice is challenge. Here my argument would be, not argument, my request to my lord would be, the price is 73 lakhs. There is 60 lakhs.
Loan is of which year?
Loan is of the year. My left leg is amputated. Loan is just travel this port.
Why do you say all that? We are asking which year. Why are you unnecessarily spending English language? We want year. That's all. Nothing beyond that. Pass on. You prepare it now. Yes. Next.
Item 3, WPC
16.
No, you prepare again. We will have some question. You read properly. Sit properly and read. Yes, next. Password.
Item 4, WPC 800126.
Yeah.
The husband has taken loan in year 2016.
2016.
Around 30 lakhs, it was subsequently 50 lakhs.
For what? Is it mortuary loan or housing loan or industry loan?
Housing loan, for petrol pump.
It's a business loan.
Yes. Business loan, house loan. Housing loan I have already cleared up. So what 60 loan is concerned is because initial 35 lakhs, which are extended to 50 lakhs.
So it's a business loan.
Yes, then there is around 70 lakhs.
The loan is of which year?
2016, right? And the fact was that the husband of the present gets son, because of his involvement in the case of NDPS, in particular land has also been mortgaged and it is being placed by the NCD, placed by the NDPS authority, the order 68 month. And still then now the authority is going on, and they have now sold the particular property to the public number 3. And Hon'Ble solution, the valuation of the property will be more than 2 crores. Now they want to settle it with the minimum price of.
You challenge it in appeal under section 17.
No, 17 will not have.
Yeah, so you have to challenge that. No, so appeal should say that.
No, they have not taken my permissions. Since now they are going to remove me from the house. And it's my bona fide products of something that's I am ready to pay the amount which they have also paid. If they have also paid, I am ready to pay it. But I buy the whole submission. I am ready to pay around the 70 lakhs. I am ready to pay 2 lakhs. I am ready to give me 7 days time. And rest part within a period of 3 to 4 weeks, I will pay the entire money. I am very protected. And my house, everything is go. I have no other house. And one thing I will take note of. Although that particular property has been filled, I am not on that.
Then the action took place.
But also they have not intimated anything to me.
No, you have to certainly. Then how can you get money?
Any also, they have author side for 20 lakhs.
Then is only section took place. No, you have to find it. They should go. You have to find the copy. Then that is what.
Subsequently, that also, and now the specific start, that money has been taken by that particular around 50 lakhs into the bank. And they are saying around 75 lakhs, which are ready to buy. And the property value is more than 2 crores, 5 because of some reason that are which I don't know.
How to say it is more than 2 crores?
But I
see the material you have produced.
I have specifically said this because the petrol pump is there, the land cost, everything I have mentioned.
No. You should take a valuer. You should get valuation report. Then you can make the submission. Otherwise, everybody will say after auction takes place, it is 10 crores. Everybody will
So I'm ready to pay.
The question is not that you were not ready to pay when it was auction.
Yes.
So once it is auction, third party rights on interest are created.
I'm going to put it, I'm going to pay some money, but when you put it, I'm going to give 7 days time. Implemented, I'll pay and then come back.
Take notice. Who appears for the bank? You appear for the bank. When the auction took place?
Certificate has been issued on 16 to 2006.
Still do. Then certificate is already issued.
Yes.
The entire money is remitted. No.
Well,
The entire money is remitted by the auction purchaser.
yes, after that, there's
Sales certificate
can be issued. Sell confirmation will be issued after 25% deposit.
Nothing expected to. You should challenge it. If it is visible, not we cannot do because of BAFNA. Never said that. There is nothing. It's not case one. It is not case one of the case. It's not a settled principle. If possible, we will always grant relief. We cannot stretch the law and we cannot make the law bend. No, we do not. If you want this one, otherwise
And the amount where I will buy, the amount will just bear, I'm ready and if you buy.
that makes no sense because he has bought that property with the intent to own it. That's the intent. Therefore, nothing can be done in that. You challenge it elsewhere. If limitation comes here also. Here also it comes. What can be done? For those who are sleeping all these days, nothing can be done.
Because of this, and thereafter, because he was in custody for about more than 1.5 years. That is the reason all these things.
When he was released,
Because he was released in 2024.
then what can be done?
And
This
therefore,
happened only in February.
That was 68 to 68 to 16, so I had to run.
You take notice, let us see whether your auction buyer is agreeable. If he is agreeable, we can do something. If he is agreeable to take money under Order 21, Rule 89, 90, 91, like that, then we can do something. If he is not agreeable, we are helpless. You take notice.
Issue is no way concern.
No, we are not issuing any. Yeah, have you made the auction buyer the party?
Yes, ma'am.
Issue.
He is the wife of the
Let us see. Issue a merchant notice. Learned the panel counsel on request appears for the OP bank. First of all. Returnable in 2 weeks. Notice returnable in 2 weeks. Okay. Let's see. Item 5. Yes,
My friend has come.
yes, come. No, no problem.
Item 1.
Item B.
Before submitting, I have taken all instructions. It's a matter with regard to loan on OSFC.
OSFC loan it is.
OSFC has granted sanction loans for a rice mill.
Rice mill.
That's
Yes.
way back in 2000.
Once. Business loan.
Because what was the purpose of it? Strong working capital was there. Because the business.
Business loan of 2000.
Of the year 2000.
Of the year 2000.
Wow.
And in fact,
How much money was borrowed and what is the outstanding amount now?
in fact, I don't do that. That's what I get to school. If you are sitting kindly down to Annexure 18, page 170.
Will not turn it. Answer the question.
Principal is 23 lakhs 98,040.
23 lakh.
98,040. Whereas the interest is 9 crore 29 lakhs 4,495.
9 crore.
25.
29 lakhs 4,495. Page 131. Then there is some miscellaneous 15,327, 15,327, and it comes to 9 crore 29 lakhs 4,128.
This is outstanding.
This is the outstanding and now
As on.
Now this is as on the notice date 10/7/2025.
Yes. Now what?
And now, madam, the auction notice, madam, is high 4979 of 2026. Auction notice has been issued and total outstanding has been placed at 9 crore 92 lakhs 52,201.
Auction notice is dated.
Dated 7/3/2026. The principal will remain constant, but our the interest has again.
Interest always grows by arithmetic. By arithmetic it grows.
This is the situation. Now, the rights will never took off because of certain things I have narrated.
How banker is concerned with all that? Banker is concerned about his money. Whether you rest with work, whether rice was cooked.
I have no, they cannot that way. There's something like it that but releasing the amount, not releasing the full amount, but the scope of in 226 will be possibly not as permissible.
Not even 220. It is 227 because all statutory work.
In that sense also because unless your lordship see they are beyond their jurisdiction, also like from jurisdictional error, also 227 will not spring into action. Yeah.
Whether the loan can be regularized. Who appears for the
Yes.
My friend activists.
That OTS 11 is very much available to him, and he has already meant that before the auction took place, they have informed about the OTS 11. They don't participate in that.
No action has not happened.
Action is on 18.
18.
Now OTS, he will give OTS application.
That application they have given that has rejected. They are to put for auction. They have made an application for.
Let me just clarify.
Rejected on which day?
Let me just clarify.
One
He
second.
has given not a OTS application. He has said, you get my interest, I will pay the principal.
That's all.
I was rejected advising him.
That is
apply-
treated by the apex court as OTS.
But they have said you apply under OTS. OTS has not been rejected. Let me just clarify. They advised me.
You should have applied. Did you apply?
But he has not applied.
Then what can be done?
Just but if you is manager, I have taken instruction, he can request for the present matter. And it's just a submission. I will not say that I am bargaining this and that I cannot do it. I am so that. He is saying that I have taken instruction when it involves money. He has to negotiate. It's not that just pray for a stay saying sympathy. He says he can deposit the principal, granted some time. But so far the interest part of it is not attacking the position. I cannot improve upon that.
Borrower had presented this petition under Articles 226 and 227 of the Constitution of India for laying a challenge to the coercive action of recovery pursuant to auction notice dated 7/3/2026. First of all, the next year advocate Mr. Appointing for the petitioner suffix that the business loan was availed in the year 2000 in a sum of rupees 25,98,014. And of that, as on this date, the outstanding amount is stated to be 9,29,44,095. First one, he submits that. And there being some lapses on the part of the lending agency, the rice mill for establishing which the loan was availed would not fructify functional. First one. Now, counsel submits, his client is ready and willing to pay the principal amount, but certainly not able to pay the interest that is accrued in crores on the same. First, learned panel counsel appearing for the lending agent, OSFC, submits that the petitioner had given a representation for waiver of the interest, and that has been rejected on 10/3/2025 with a suggestion that it was open to him to apply for OTS if he so chooses. However, petitioner did not avail that opportunity till date, and therefore this court should not interfere in the jurisdiction. First, we agree with this. Next part, in the above circumstance, petition is dismissed. No question.
In fact, I knew that he cannot.
Therefore, you say properly. You can't improve what your client has said, you have to say. What can be done? That will matter. Yes. What? 3. Yes, gentlemen.
And six.
And just C. Six.
And it's
Six.
six.
It's in your language.
I have taken 4 loans. One.
4 loans.
4 loans.
What are they? What?
One. During the COVID period, then sister, I was still some loans, so I have, and I was paying it regularly. In the last December or November, I have also paid 50 lakhs in one of the
Total loan is how much?
loan is 50 lakhs. I am ready and willing to pay.
Originally availed money is how much?
Originally, how much money you had availed? And in which year?
Together. Approximately.
I cannot say.
What is the outstanding amount now?
Outstanding right now 58 lakhs. And
As on
John 26 to 2026.
26 to 2026.
Yes. I have,
You have paid up to which date?
my lord, I have from 2025 November, I have paid 50 lakh in gas credit. So far as gas credit loan is concerned. But there are I have defaulted in paying the other loans. So I am ready and willing to pay to clear the 15 lakhs immediately. That is house building loan. Immediately, within 15 days, I will clear it. And rest, I only need some time.
What is the position now?
They have issued the auction notice, which is 6 to 30.
But you can take up all these contentions within the appeal.
My lord, they have not filed any DRT proceeding this month.
No, they need not be.
Yes.
Even against this order, it is challengeable.
Seventeen is there?
When they decide to go for auction, it's an order.
Yes.
Then you can avail under section 70.
17.
Give it to 70. Observe. Yes.
It's a
Let's say.
second.
Which is the which is the best book, best commentary on Surface Act are not available on today.
I have worked, so I cannot say. I cannot.
Any of the measures referred to in subsection 4 notice also. Any measure under that is challengeable in the under section 7. Section is very widely worded. Can you see this? Any person, including borrower, aggrieved by any of the measures referred to in subsection 4 of section 13, taken by the secured creditor or in authorized officer under this chapter, may make an application along with such fee as may prescribe to the debt recovery tribunal having jurisdiction also within 45 days.
And cell notice, there's already the
If the cell notice is under 13(4), it is perhaps.
34.
Yes.
Notice was 34.
So it is available, not available. You can have the grievance redressal before the tribunal. We will permit you to go there. No.
You know, we cannot.
We cannot because
Protection, if even then I will go.
what protection?
My lord, if it will be put to auction,
Ah.
in the meantime, if any
When the auction is scheduled?
30th.
30th, you go immediately tomorrow. After all, you are not trying the question on the petition. Simple. Why, whatever grounds you have already taken here, you take up before the
That is why my may I pray your nursing to keep it to after dance. Let me talk.
No.
Otherwise, my
We don't need your consent of your time to pass further.
this is my lord that I
Okay.
am not there. But
Petitioner borrower is knocking at the doors of the court, being aggrieved by notice issued under subsection 4 of section 13
30th.
of the Surface Act 2002. First, section 70 one of the act which reads as under is very widely worded and it provides for grievance redressal in a matter like this. First, reproduce there. In the above circumstance, this petition is disposed of, reserving liberty to the petitioner to avail the statutory remedy as indicated above. First, in that connection, all conditions are kept. Next, the registry to send a copy of this order to the lending agency by speed post immediate. Next.
And copying it given to you.
Yes. Give it copy before 12. Yeah.
Item 5, same appeal 3927/22.
Restoration now. Yeah, we'll restore it. You have to argue tomorrow. Amri. Then delay.
It's no deal, but it's a part of a delay. On 16 is 2022. On 29/8, IA was filed, but a certified copy of the order has not been filed.
Sorry. But you have filed the IAV in time.
In time.
In time. Mr. Who is your opponent?
Still,
Mr. Monty.
16/8 and
We'll restore it. But dismissal for default is not a happy thing.
let it become merit.
That's one. Judges, why we should resort to that? There are so many cases which we can take up. Why to dismiss unnecessarily? Take no. The application seeks, application supported by affidavit seeks a restoration of the main matter after recalling the dismissal order dated so and so, founded on non-prosecution, on the ground of non-prosecution. First, a plausible explanation has been offered. First, this apart, denying justice to a worthy litigant on technical grounds is not a happy thing to happen in the constitutional courts. First, nobody comes to court with the joy in heart. First, they knock at the doors of the court only when it becomes inevitable. First. Next one. Keeping all the above in mind, the application is favored and the order dated 16/8/2022 is recalled. And as a consequence, main matter, that is WPC number 5753 of 2006, is restored to the board for being argued tomorrow. First, yes, you have to give it, cannot be free. What will you give to the bar association? You go to book. It cannot be free. See how many years your client has wasted. Which book you will give? Give PC Moga's law of pleadings. Petitioner shall present the book, Mr. PC Moga's book, in words, law of pleadings, to the association library. Right today. Yeah. All right, within 1 week, within 1 week. Call this matter on, let me you on 7th of April, right? If a book is not presented, application shall be treated as having been dismissed. Okay. Next.
Item 6, WPC 2511/23.
23, Union of India. Union of India, maybe elsewhere. All right. Also, let us see.
Item 7, WA 228/24.
Yes, Mr. Yes, appeal.
State of Tenement, challenging the order of the signatures, 6/1/2023.
Yes.
But the two similar
Go to the
matters are
other.
there. But it is a limitation of 370 days.
300,
70.
370 days.
It is like even more than 1 year. In another similar matter, my lord says
Notice is
delay and notice to issue. May I supply the copy?
Why we believe you?
No, but this copy is there, because
Give. Issue. Emergent, whether the 20 rupees rule is made there.
not made, but you will
We will make in that also 20 rupees now. Issue emergent notice, returnable within 2 weeks, both on main matter and the IA. Subject to petitioner, appellant, petitioner, the appellant depositing with the registry, a sum of rupee, registry, a sum of money at the rate of 20 rupees per day of the within 10 days. Within 10 days. Failing which application stands rejected and therefore appeal as well.
file the IA because content is there.
Well, what can be done unless
It is posted to 20th this month.
the contempt court is requested not to precipitate the contempt proceedings in contact
292 of 2024.
for some time. We can only request the court. We can pass order, but we are not condone the deed.
Right.
Yes. Previous one, this one. IA number 4306 of 2026, supported by affidavit, seeks certain rectifications, which we find justifiable. First, in application is allowed. Registry to rectify the mistakes as indicated in the applications. Okay. Next. Energy preferences. Yeah. Tell.
See, actually, question number the loan was obtained.
What is the nature? See, we have a standard format in this way.
My lord,
Nature of loan. When it was allowed, availed. What is the repayment, debt servicing done? What is the amount as on this day? What is the stage of measure under the surfacing? These are the standard
my
patterns.
lord, my
Yeah.
account was opened in the year 1992.
Loan was taken in 20.
Account was opened 93, the loan was taken.
1993 loan, business loan, housing loan,
Credit loan, cash.
That is
business loan. How
My
much?
lord, in 22 NP.
How much?
My lord, that is 1,36,24,700.71.
1 crore 36 lakh.
24.
1 crore 36 lakh,
Hmm.
24,701 rupees 0.71% plus interest. It will be evident from annexure 1.
Okay.
Then, my lord,
This was in 1993.
this was in 22. One account was operated, it became NPA on the year 2022.
No, what was the amount you had borrowed?
It is a cash credit.
So,
I will
so
take
it has come to this extent. Now it is on 20, in 22, it is 1
1 crore 36 lakhs 24,701.71.
As on?
As on 1/11/2022. Annexure 1, it is evidence.
Yes.
Then, my lord, it come across a OTS plus scheme. I approached the Honorable High Court permitted me. The OTS was allowed.
What was allowed on which day?
My lord, 9/9/2025.
OTS was accepted.
Accepted 92 lakhs was the amount.
1 second. 99,
9/9/2025.
which is that document?
Page 51 and Excel 8.
Go to annexure. On or before 30/11/2025, we were supposed to make payment.
I could not.
You could not. Then what can be done? It's the OTS.
My lord. I paid 4 lakhs subsequently. This 9/20,000, then 4 lakhs also I paid subsequently.
Nothing can.
13 lakhs or I have paid. I am ready to clear up all interest and everything within a short span.
Already you have received the concession. Even that you have not done.
My left leg was amputed.
No, that is no ground.
I know my limitation, my lord, in this statutory matter.
Otherwise, we would have granted to the apex court said.
I people of the government leave and submitted to. I am paying substantial amount within a week.
That makes no sense.
That they have made the option amount 73 lakhs. I will deposit it within a week.
Nothing. When the auction took place?
Option took place on this was on
Long second. 2023 is that.
the option already by now. Therefore, I have made the private party as a party. Option hold.
Not telling which date. We are very much off to the date and time. Although we are not launching the satellite.
22 to 26.
22
to 26.
26.
Date of auction.
Well, you will also get it on page 59.
You file appeal under 17. We have done it to Jana Madam's case. Jana Madam will ask why discrimination.
No,
You ask just to go to the DRT and in this case you are interfering. What answer we should give in the corridor?
No, I don't know. I am hearing it. I am speaking here. I am.
But same applies. What applies to goose applies to gander. Equality. Take on. Petitioner borrower who had taken away the cash credit facility totaling to rupees 36,24,701 was given OTS facility white letter dated 9/9/2025 for a sum of rupees 93 lakh.
22 lakh.
92 lakh. First one. The OTS amount having not been remitted within the prescribed period, comma, the lending agency has caused public auctioning of the security property on 22/2/2026. First one. Aggrieved thereby, petitioner is complaining in the writ jurisdiction. Now, having heard learned from the petitioner and having perused the petition papers, we decline indulgence in the matter in as much as the terminology of section 17(1) of the Surface Act 2002 is too wide, and grievance of the kind can be worked out by the petitioner by invoking the said section. First, for the ease of reference, the said provision is reproduced below. Next paragraph. In the above circumstances, this petition is disposed of, reserving liberty to the petitioner to avail the statutory remedy as indicated above. First, all conditions in that regard are kept. First, while computing the period of limitation, the period in prosecuting the writ petition is liable to be discounted in terms of section 15 of the Limitation Act 1963. First. Next.
Item 8, WA 362/25.
Yes.
My lord.
Ah.
Appeal preferred by the state. Challenging the order, judgment dated 9th of August 2024. In which your worship have directed to
Single judge has read.
yes,
Yes.
next one. She directed that the writ application is disposed of, directing the opposite party number 1 and 2 to pass necessary orders, grant regular salary to the petitioner in the scale of pay of rupees 9,300 to 34,200, with grant pay of rupees 4,200, with all subsequent pay revision as may be occurred from the date he was appointed as Anganwadi supervisor on contractual basis till the date of her retirement. Such payment shall obviously be made by deducting the amount paid to her towards contractual remuneration. Since the petitioner is already retired, necessary orders shall be passed within 2 months from the date of production of certified copy of the order by the petitioner.
Retired on?
She is retired.
On which date?
Date of retirement is not there. 24 April.
24 April?
24 April.
Sit down and answer, sir.
Please.
24/4
2024.
April.
April. 28th of last year.
See, for other 9 persons,
Well,
that pay scale is given.
well,
Why not to her?
well, I'm coming one after another. That's the timely.
On what grounds the relief is accorded by the single judge to the litigant?
Well,
What are the grounds?
yes.
How they are wrong?
Well, I'm coming one after another.
Yeah.
As in the year 1997, on 17/2/97, posts of 1,015 number of temporary posts in respect of 85 ICTS projects offered.
No, all that is irrelevant.
My lord, this is relevant because I'm coming thereafter. This is relevant because these posts were open for Anganwadi workers. Well, previously there was a resolution that from out of the Anganwadi workers, those who are having qualifications, they will be promoted to the post of Anganwadi supervisor. Supervisor is just carrying. My lord, thereafter,
Supervisor is last sentence, you say.
my lord,
Scale based.
Scale based. Pay scale.
my lord, on 4/4/2008, government took a decision that in pursuance to the finance department result observation, 237 posts of supervisors carrying the scale of pay of rupees 4,750 to 7,500 were abolished in this department letter number so and so 4/4/2008. It is essentially required to fill up those posts for implementation of ICTS program. The same number of posts of supervisors are created against the abolished posts in different districts mentioned below on contract basis at a consolidated salary of 4,750 rupees per month. The appointment on contract basis is subject to terms and conditions as stipulated by Finance Department Circular number 72 dated 31/2004
and other circulars as may be issued from time to time.
Mr. Chief,
Accordingly, my lord,
you are only reading, that is not argument. Anyway,
my lord, after placing the
when she was promoted as supervisor,
in the year 2008, sorry,
as on that day, whether the courts were abolished, that is the only question here.
yes. My lord, so far as,
No, we answered our question. When was she promoted as supervisor?
my lord,
When did you abolish the court? You abolished on 4/4/2008. When was she was promoted as supervisor, or when she ought to have been promoted as supervisor?
no, she was promoted in response to that post and created contractual. Against the contractual vacancies, she was, there are certain concessions.
All right. One more question. Whether after the abolition, did you promote others given the statutory skill?
No.
Kindly come to the order.
Well, now,
Go to the order. Annexure 1.
yes. And placing the order so that it will be easier.
There is a record finding is there.
Yes.
Then you go to the order.
My lord, page 26. Page 26.
Yes. Come to running page 26.
26. My lord.
Ah.
My lord, the district social official so by letter dated 34/2008 directed the petitioner
Along with some other Anganwadi workers to appear before the subcommittee on 3/5/2008.
Yes, this is the date in the office of the sub-collector for the purpose of assessment of their suitability for promotion to the junior grade sergeant. Pursuant to such direction, the petitioner and others appear. Out of whom 10 persons were promoted to the post of supervisor on 16/9/2008 and were granted the scale of pay of rupees 4,700 to 7,500. Subsequently, the government in the Women and Child Welfare Department issued a clarification regarding filling up the post of Anganwadi workers by graduate Anganwadi workers who have completed 5 years of continuous service. Accordingly, the gradation list of such Anganwadi workers who had appeared before the district of Jajpur on 29/7/2009.
No, Mr.
Minor.
P. You have appointed others. You have sanctioned the pay scale to them. Why not to this lady?
My lord,
Is
because
it your case? The finding of the learned single judge is wrong?
no,
Have you taken up that contention?
no,
Then you have to-
it is not there.
Then how can you discriminate? Kindly read it.
My lord, because of the fact that the posts were created in the year 2000.
But for them also, for others you have done. For 9 others,
No,
you have given, yes, there is a finding. It is not your case that this finding is unfounded.
out of 10 persons were.
Yes,
Out of whom 10
9 you have given.
promoted.
9 you have given. Why not to this lady? How can you discriminate? How can you be discriminatory? You are a state entity. You have to be a model employer.
They were from the regular vacancies that come. Not against this.
Under the same DPC, all they appear. See that, even date is given. You had mentioned the date on 3/5/2008. They should appear before the subcommittee.
Yes.
Subcommittee held the proceedings. Then recommended all of these people for the post of supervisor. You have given the pay scale for 9, but to this lady, you want to be a stepmother. How can that be?
Because the appointment was made against a contractual vacancy.
No, even after 5 years, yeah, they would become regular.
My lord,
But why did you do it to others?
my lord, after 5 years, my lord, they will come to the fold of supervisor. However, there was a concession. Previously, it was 10 years. It was reduced to 5 years.
But anyway, you have given to others. Learned single judge has said.
Because they had completed 10 years.
No, that's not your case in the appeal bill.
There is no-
Yeah.
There is nothing.
He was saying how he
It
is
is outside the pleadings.
outside.
Other day, a similar matter which has been disposed of earlier by the Hon'Ble, this has been confirmed by this division bench of this Hon'Ble court. my lord said the other day and posed the question whether that person and this person is similar to or not. Exactly, they are similar to the appointment, everything. And even thereafter also, this honorable single bench which has been passed under challenge also passed another judgment on the
Similar or contrary?
similar, my lord. And their order has been passed to left it to the government to take a decision. That is
No, that may be. That is no ground. Because his order is before challenge.
and originally, when the Hon'Ble workers is a schematic, it is a scheme of the central government. Subsequently, government came with a proposal to fill up all these vacancies because supervisor posts are vacant for a quite long period. So making a relax, the person those who have appointed, if at all not completed 10 years, because before that it is urgency for the interest of the state, they are relaxing that one person should be a graduate one and completed 5 years of service. Then he can directly come to the consolidated pay of rupees 5,000 to the post of supervisor.
What about other?
Well, others have not got it.
No, that's not your ground of appeal.
That
The ground of appeal, all others were graduates. She was not. And therefore we are not extending. That is not your case.
because of exercise of the option, they have been considered. Had they not been exercised, and after 10 years, definitely they must have got the benefit of supervisor.
No. Yes, what do you want?
And similar order also, coordinate bench, my lord,
So you mean to say that these 10 who have got the promotion are not equal to the one of the petitioner? Since they have not completed 10 years?
this person,
Huh?
this person, no.
5 years.
5 years, after completion of 5 years.
Those clarification to Lordship. 1983, I was appointed as
So
an
that year,
worker.
okay.
1992, I became a graduate. The time takes 1983 as an Hon'Ble worker man. I got my yes. Then before I will just take pre-documents of the writ petition subject to your Lordship's approval.
But so many years, therefore the question of graduation will not arise at.
1992, I am graduate.
You are graduate also?
Yes, 1992, I am graduate.
Yeah, brother, she is a graduate also.
1992.
Therefore, 10-year rule also will not be applicable.
My lord, by
Now what-
exercising their option, kindly have a glance to the appointment order for a moment. Appointment order.
You had sent her for to the committee.
1/6/2010.
Correct.
Can have a glance to the
1/6/2010.
Yeah.
Which is that document?
That is in the counter affidavit to the writ petition. Yes, by
In the read.
that is F/3.
F by 3. There is an order dated 1st of June 2010. Page 64 of your Lordship.
69, 64,
64.
F3.
F3. I would beg your Lordship to mark where I have been posted.
Without
ICDS, Vadachana.
Serial number?
Serial number 1.
what's for what?
Then I take your Lordship to page 25.
Reflect appointment.
Just a minute.
In the post.
Then I take your Lordship to page 25.
Consolidated.
A person
Seven.
at serial number 9, if your Lordship is perusing page 25, to say it brief.
25.
25. At serial number 9, Manjula Tabera, ICDS, Vadachana.
25.
She is appointed in the year 2008. That is Annexure 3.
Miss 25
Yes,
That is
page
of the
20,
writ petition.
writ petition.
Of the
order.
writ petition.
of the writ petition.
Order
Annexure 3. Annexure 3 of the
Annexure
writ
3. Page 25.
Appointed on 16/9/2008.
Yes, these are the persons. One of that Manjula Tabera, ICDS Vadachana, at serial number 9.
That is your client.
No, somebody else.
Some other.
Yes, some other appointee. This Petitioner, why I am emphasizing on the word Petitioner, these posts in the Petitioner IGS was created by government notification of 1997. Then in 2008, one is appointed
Is posted.
at ICTS Petitioner.
And she is getting pay scale, salary in the pay scale.
Yes. And I was appointed by F3 in the year 2010 at serial number 1.
To the very same
Petitioner.
vacancy.
Yes.
To the same vacancy.
To the vacancy created under the same ICDS.
That's contractual.
It was in.
I haven't concluded. Why you it is concluded? It was contractual.
Yes.
Posts were abolished and contractual posts were created.
Now in Annex 8 in 2001, if posts were not created or abolished, Annex 8 2011, 9 persons,
23/12/2011.
yes, with scale of pay, these 9 persons were also appointed.
And they have been given the scale.
Yes. 2008, they gave them scale.
Yes, Mr.
2011 gave them scale. 2010.
They have
no.
given the pay, salary in the pay scale, not consolidated pay. That was our question. After glancing the reasoning of the learned single judge, what struck to our mind was why she has been singled out for step to the treatment.
What? We are just placing the fact, we are not saying the word. So for the F3 to become document my learned senior as the best Miller, I'll pay 64.
Yeah.
For a moment, Miller, I am the leader.
Only one question we want. The 9 persons which figure in Annex 8, this is dated 23/12/2011. They have been given the pay scale, salary in the pay scale, not consolidated pay. How she is different from these people?
May I clarify? Some of the candidates, those who are continuing having the HSC qualification under the Anganwadi workers, government has come with a proposal to fill up certain post of the post of supervisor, which is upgraded one, and it carries the pay scale. But because of the completion of the 10 years before that, though it was required to fill it up, so accordingly option was exercised and sought for the option those who are interested to upgrade it to the post of supervisor before 10 years, they can be very well appointed on contractual supervisor with a consolidated pay. My humble submission on that is the document. So before completion of 10 years, some of the candidates, those who are continuing as Anganwadi worker, they have exercised their option. Yes, before completion of 10 years, we can get the benefit to be upgraded to the post of consolidated supervisor. So accordingly, keeping in view their option, 287 million, candidates have been upgraded to the post of Anganwadi supervisor. Can have a glass of 60 for the language.
Pay 64.
Exactly, Miller. It is at by 3. It is oriented 1/6/2010. Without prejudice to the
Annex 3. Yes, 3.
Exactly.
F3.
Without prejudice claim of others that the following Anganwadi workers are hereby engaged as a lady supervisor on contractual basis at a consolidated salary of such and such as per month WC Department instruction contained in 4/10/2008 read with finance department supplementary number 2004 and subsequent instruction contained in WC Department number 2010 in place of mention against each under the following terms and conditions. Then in that list, the present petitioner also exercise his option to be promoted or to be placed as contractual supervisor before completion of 10 years. Accordingly, keeping in view her consent and option exercise, she was found placing serial number 1. That is contractual basis supervisor. But the person those who have waited up to 10 years in a normal course, they have been promoted to the post of supervisor, not
That is so.
contractual.
She was appointed in the year 1993.
83.
83.
92 is my graduation. By this time, I am,
92 is her graduation.
yes, by this time, I am 18 years into the graduation.
The original appointment is also on contract. So far this Anganwadi workers.
But once others are appointed and they have the same qualification, they are graduates.
They are graduates.
And that is the reason graduation coupled with number of years.
10 years.
10 years, no, it will be 5 years.
5 years.
If option is exercised.
If at all they will exercise their option to go for the contractual supervisor, then 5 years will be relaxed and they can get the benefit much prior to their date of
I will ask one question to you. If candidates are graduates and they have already put 5 years of service, what is fun in asking that they should exercise the option? So, without exercising option, they will retain the small amount.
No.
Huh.
Exactly. Because
No, Mr.
government has instructed public collector.
One more analogy. The post at Barchana is a post of permanent nature, of scale of pay. If you have given an option to the candidates who had not completed 5 years or 10 years with graduation, she would have given in a contractual post which you have created, if at all. But you have not created any contractual post. You have created, what is that? You have posted him.
No, you are posting. You shall be regular vacancy, not contractual vacancy. That is simple.
By this could as the confirm the order of the honorable single.
What is that?
No, watch it. It was a case of contractual appointment. But this is a case of regular appointment.
No. Indian bench, the concept was the person was appointed against a contractual post. No juniors were promoted subsequent to his appointment, her appointment, and she could not prove before the Honorable Lord that her appointment was regularly done.
That is the difference.
Yes,
That makes all the difference.
the latches of the petitioner there, they're taking advantage of it. And with due regards, my
It was a case of contractual appointment.
yes,
This is a case of contractual appointment but to the regular vacancy, not contractual post as such.
The contractual posts were abolished. And
No, as on the date she was appointed. He was appointed in the year 1983 as Anganwadi worker.
It was contractor.
It was contractual.
Yes.
But she became graduate in 1992 after the appointment. And she gained entry to the regular post itself.
No, she has not got.
Well,
No. How can he, man? Unless he is promoted to the post, man.
her appointment was to the regular post only.
No. If her appointment was against when she was the Anganwadi worker, it was a contractual post.
No, no. The vacancy to which she has been appointed is a regular vacancy.
No, let's see that I
these queries,
Yes.
these queries will be set at rest if your lordship sees Annexure 11, page 43, is the order of my appointing authority.
Lordship,
Just a minute.
the
Your
appointment.
lord, first I approached your lordship, I was ignored. And then, if by virtue of your lordship's specific direction, I approached my appointing authority through a representation. What my appointing authority, the collector Jaspur has found. Are they aware of that? I take your lordship to page 43 of the writ petition. Then reduces the latches of the government. And collector comes forward to say that I should not have been ignored. I take your notice to page 45. The finding of the,
Collector has asked for it also.
yes. Second, my lords, I take your notice to page 44. 44 is the finding. Your lordship may go to page 45. The DSW Jajpur has not challenged the eligibility of the present petitioner for promotion to the post of ICDS supervisors as per the eligibility criteria provided under the rule, which leads to the assumption that the present petitioner is eligible for promotion to the post of ICDS supervisor. Secondly, as it appears, accepting contractual appointment to the post of ICDS supervisors by furnishing a no objection for such appointment and an undertaking not to claim regular scale and DA and other allowances is not a bar in the instant case for considering a promotion to the post of the ICDS supervisor. The ratification in the regard would have been sought for from the government in case of doubt regarding elimination of the names of the Hon'Ble workers accepted contractual appointment and whether their cases are fit for consideration for promotion to the post of ICDS supervisors. Elimination of the name of the present petitioner from the judicial list in absence of instruction or clarification from the government only on the presumption that she also eligible to be promoted to the post of ICDS in accordance with the eligibility criteria provided on the rule and making her prejudicial of being promoted to the post of ICDS supervisor appears to be irregular. In view of the facts discussed above, this court is inclined to hold that a present petitioner has been prejudiced of a legitimate claim of being promoted to the post of ICDS supervisor only because of misrepresentation of facts. This is what my appointing authority has come to a conclusion. And in spite of this finding, when the authorities were silent, I approached your lordships again. And when I approach your lordships again, this is the order which is under challenge before lordship. Now the funny part is, the irony rather, I will beg before your lordship, I have given a document to your lordships the other day. Government of Orissa, in its Department of Women and Child Development Department, has, by virtue of a resolution dated 25/9/2024, after my retirement, has given a resolution that all these persons should be regularized. It is right, a government notification, and it is gazetted.
Dismissed agreeing with my lordship that I single judge's order.
Kindly have a look, my
First, further, there is observation when another learned single judge in petitioner's earlier WP 22017 of 2012, I have given a comparative survey decided on 21/12/2012, where the following observation appears. See, page 45. Okay, 45. And yes, or the decision just to be implemented within an outer limit of 8 weeks without giving scope for contempt action. Okay.
Good. And you will a comparative chart panel.
This one, no?
Item 9, need a page 422/2025.
Delay to be condoned. Will you condone the delay? Yes, that's what 130 will be. Next.
Item 9.
Yep. Your wife is sister. You have not eaten your breakfast today. Yes, be louder. This matter where medical negligence case,
Yes.
recommendation of the collector of Cuttack
Yes.
for 80,000 rupees.
Well, here the honorable court has directed for to form a committee and take a decision.
No, not for that. It is for medical negligence.
No, 80,000 you have to pay
80,000
for.
you have to pay.
Other things that the Lord says.
Other things, yeah, well and good.
That is all right.
Like 80,000 is recommended by your collector. After looking into all that, and this is ex gratia. 80,000 is an ex gratia,
This is not on the merit of.
not merits at all. Which is that page number.
One order.
That's something. Turning page 140.
Of the writ petition.
An exact figure.
13.
And
Yes,
Yes, you are not.
that is there.
This amount has to.
It is not.
It's ex gratia. Under the Chief Minister's Fund, perhaps. Chief Minister's Relief Fund,
And this has been directed since 2021.
2020. You have not paid 80,000 rupees to the person who is suffering. Now, no more.
That was with reference to some to say that so and so has submitted an application for sanction of financial assistance out of Chief Minister Relief Fund for medical treatment who is suffering from cancer. A report by medical officials
As reported by.
as reported by
Medical.
has incurred an expedition of 80,000
What treatment cost?
You pay it to the widow. Now husband is dead and gone.
whenever it was government.
I do hereby recommend. Collector is recommending.
It is not your case that she is not entitled to.
Yes, recommended to the Chief Minister
Yes. At 2:30 we call this matter. At 2:30.
at 2:30
Tomorrow you do it.
tomorrow.
Tomorrow.
Tomorrow or day after tomorrow.
All right. Day after. Final. What was our order earlier?
To pay.
See, by our order dated 12/3/2026, we had said as that. First time. Next paragraph. Learned AGA, Mr. G, very fairly submits that he will confer with the client and come back with some positive response. Keeping in view the observations in Annexure 23 of the application dated Annexure 23 dated 21 February 2021. A copy whereof awaits at Annexure 23 of the writ petition. The same reads as that. Reproduce it. Basically,
Located 12/3/26. Today's order.
A copy of this order shall be shared, a verbal copy of this order shall be shared with the Lovett AGA for immediate action. Yes. No, let us see. Let the 80,000 is first pocket. Next. Let us, next.
Item 10 has been adjourned. Item 11,
I,
WPC 3977/2026.
Yes, Lord. So where I had two like application for documents. What has happened, Lord, may kindly have a glance into Lord order. That is order chapter 9/2026, where an Lord we will say power that is delegated, function is delegated to appeal remedy, keeping open all the contestants. My Lord, my specific case is that, Lord, behind my back, the auction has been taken off. And for that, I sought my document in accordance to your.
challenge that also.
Yes, sir. I not to challenge things. You not challenge that document is required notes. Substance of it. For that notes, I sought for your lordship may kindly come to notes of this miss case IA number. IA page running page 5 times 3 minutes. Come to that. I have given everything, lordship. That
Why can't you go to DRT?
Yeah,
Challenge the order itself is of DRT.
DRT.
Where is that?
No, I have no. I have not challenged that order. So, in order to prefer an appeal under section 17, the very option of appeal is required.
Who says this on? Read 17.
They are saying.
Read 17. Read 17.
They are saying the truth.
Why can't you read 17:1? Most of the problems will wither away if you read the text of the law. But because laws are made with rich experience. Really read. But read first. Read 17.1. The word used is measure, not order at all. Other sections will say any person agreed with the order. That's not the text.
This is the active measure.
Therefore, appeal lies, your application lies, not appeal. Your application lies on the measure, but not on the order.
And don't ask the other side. They may misguide you.
As already of me. We'll make that observation.
Yes. Yes.
I am appealing for the bank note.
Prior to that, what they said, what they said. They said, this is document 6 minutes. They said, the information sought by you through your letter number 1326 towards requirement of option copy is confidential. They are saying that's confidential. It's not public document. How can they say, oh, this is confidential? This is
You take notice so that they will give option copy. We'll direct them to
Yes.
copy. And then you can prefer. That will
nice.
issue emergent notice. Returnable within 2 weeks.
I am appealing for the, on behalf of the bank note, sir.
You
I'm
are not
appealing
giving
the-
the option copy saying that it is a confidential record. Is it confidential? Official Secret Act.
Let a copy of the IA be sought down to me. So that I can, Yes, sir.
Last time, issue emergent notice. First, learned the panel counsel Sri finds so volunteers to appear for OP numbers.
Only one.
OP. First up. Petitioner to serve copy of the petition along with all the documents as well. The IA along with other documents. The panel counsel right now. First of all. Since matter lies in a narrow compass, all the same. We have to fix it.
What has happened in the meantime, so without supplying me a copy, I have applied on 13th. You also applied on 9th. I have applied on 13th. They have supplied the copy seeking for a lot time and 27. And saying this, that in the meantime, they have prepared an case before the CJM Jagasimpur under section 14 of the Act, saying to tell about
That is the independent proceeding. That is the
They will
independent.
get you. You are not precipitating them.
You are not precipitating section 14 proceeding.
Yes. That is the final remedy. And the bank has had issued the caveat notice annexing the notice, and the petitioner has avoided, which has been returned unsolved. Knowing he has avoided.
Are you from Delhi?
Yes,
Are
Lord,
you
I
from
am
Delhi?
from. I have some health issue, but that is why I am calling. Otherwise,
When will you be all right? We'll request you to choose a date. You come here. Otherwise, time will be wasted. Like.
for today only, I have.
Call this matter. But in the meanwhile, sir, you should not precipitate 14 application.
in this case, no 11 of them.
So the Lordship would see that the 14th, section 40 doesn't provide any, that is the
We
procedure.
are not able to understand.
Section 14 is a consequence. All right, you will be going for consequence.
After confirmation of sale to the auction purchaser, the only remedy of the secure creditor to seek the order from under section 14 from the
yes.
judicial matter.
But you are not given the auction order at all.
How he will go?
How he will go?
Auction order I can do. Just now I can serve him. Not
Okay,
can pay. He should, the petitioner should approach
Physically, you come here first, then we can hear. Otherwise, complete hearing.
I am solving in course of day through my associate in course of day. The Lordship can make the observation of that. I am solving.
We'll call this matter.
We'll call this matter, all right. Tomorrow you are here.
Tomorrow, can you come?
Yes, Lord.
Come. This matter tomorrow. Well, he is coming tomorrow.
But here, in case what is happened, man, then
Because
the petitioner is a practicing
even
lawyer.
14 nothing will happen. Let it come.
That's it. Yes, come on. So I'm diplomatized with people nursing, but take this so they and because here they are not supplying and they are pursuing further with that case.
Yeah,
But
let us see. Let us see. Tomorrow, let us see. Yes.
Item 12 has been urgent. Item 13, WBC 1587.
One second, we come back in a few days. Very few days. Central Government Union of India application of
No, it's in proceed.
six.
Now you are in 14. 12.
Same.
In terms of where master instruction. Seek instruction but not proper instruction received. In the meanwhile, petitioner also filed a memo stating in a document with director and consideration of the representation they have also filed before the court. What has gone through this system? Also copies after the so as it gives to after changes anywhere both the things I have taken instruction.
On 6th of April, we do. Call on 6th of April, it's very clean of party. Yes, very important.
Positively, my actors for that's it. Positively, so
Item 13, 14, 15 have been urgent. Item 16, WBC 63 of 2026.
Like I'm challenging the order of the Central Advocate Tribunal, the next one, where the Central Advocate Tribunal has the accepting the judgment of and have the stay disease of the judgment of the Honorable Calcutta High Court, the one Koran Nerala Naroda Vidala Samiti, which was traveling to the Apex Court in the 2022 and filed the attempt to clear by the Honorable Apex Court. That was the judgment had not fully accepted by the stay disease by the Tribunal.
What was the case?
Yes, the one the senior teacher of the Kendriya Vidyalaya Sangathan was imparting the private tuition of a girl of the 12th standard at the time of imparting the private tuition she was the 17 years sexual assaulted to her, which was recorded several times sexual assaulted to her, which was recorded by the parent and called to the police arrested to the teacher, provided to the jail. After 2 months, she was released from the jail
or custody.
To the custodian bail. On bail, he was released and on suspension, he was transferred to another KP and Department of Proceedings started under Article 81B of the Kendriya Vidyalaya Code, where the termination was issued after preliminary inquiry, summary inquiry, and opportunity given by the appellate authority, personal hearing, all the departmental proceeding completed. He was participated.
Want to know whether before the tribunal, the disciplinary action was challenged.
Disciplinary action was challenged and authority, the departmental proceeding was challenged and appellate authority order was challenged and permission that
Who is your opponent?
my senior is the opponent.
Ready in the matter?
Yes, ma'am.
Start.
Now I am only placing the operation part of the order, that is running page of my
What the tribunal has said.
that is the tribunal file, that is running page starting from the 23 annexure 1.
No, that's not it. But what has it has done? One sentence. Allowed, not allowed, rejected, or relieved him from the disciplinary proceedings. What is that it has done?
Here was the entire departmental proceeding and appellate authority order and directed to pay all the consequences when we retired mental benefits.
Few questions we are asking.
Ma'am.
When the order was lost.
Department of Mine.
Punishment order. When the order was passed, when appellate order was passed,
Mine. The order passed, my lord, that is running.
Date.
My lord. 28/6/2021 at running page 405 to 414.
dismissing.
Termination order passed.
Is it dismissal?
No, termination.
What is
Under
the
80
termination?
Termination under Article 81 removed to go with the 1 month salary without giving any benefit to the
Termination simpliciter. Simpliciter.
with all the his
Yes, but it's a removal simpliciter.
this is the termination.
Yes, termination simplicity.
Right.
Yes, that is it.
I have put it Article 81. Fine.
Then this order is made under Article 81.
B.
81B of your bylaws.
Of the Kendra Vidya Code. Kendra Vidya Sangathan Code.
Code.
That is quoted.
Kendra Vidya Code.
I have also filed all the xerox copy of the Article 81. I have quoted that in my repetition.
What is the nature of code?
Mine.
Is it
That is the mutatis mutandis under Article 80 of CCS. The Article 81B specifically provides.
Why can't you hear our question properly?
Mine.
Why can't you understand our question properly? Simple English,
Right.
matriculation English you are speaking. Whether the code is promulgated under any statute,
By the Board of Governors.
not by,
By the Board of Governors.
not by. We're asking, kindly understand the English. 10th English. Whether your code is enacted, promulgated under any act of the Parliament or under Article 309 proviso or under any particular rules which have got statutory force.
That is under the statutory force by the KBS Governor, by Governor, Board of Governors, because it's the independent body of the KBS is independent society under the state.
You don't want to answer perhaps. Or you don't want to understand at all. Let us not understand the judge. If that is your oath, we are helpless. Understand. We are using the word under, not by. By whom it is made, we are not concerned.
Right.
You've got problem now. Under which law?
Under the Kendriya Vidyalaya Sangathan Code.
Code is under which law?
Code made by the Board of Governors of the country.
Under which law?
Under which law? Our question remains unanswered.
Is there having?
We are not asking by whom it is made.
Man.
Maybe it is made by Queen Elizabeth. We have no issue.
Man.
We are asking you, under which law it is made? Because we want to know. I do not know it.
What is the source of power for the code?
Making the code?
Under the board made by board under the Society Registration Act, either the independent body.
Society Registration Act.
Society Registration. Society Registration Act.
Federal Society
Registration Act.
1911 or something like that.
My lord. Then that is 1860.
1860.
60 Act 21.
Okay.
Sangathan, an autonomous body and registered society under the Society Registration Act 21 of 1860. And the power of the board has decided to, on the Article 81B, which I have already quoted, the termination of service of an employee found guilty of immoral behavior towards students.
Where is that?
That is running page 4, I have extracted, also filed that copy, page 4, my lord. My read, petition, page 4.
Page 4.
My lord.
Kindly, we request you, kindly be slow. If you are slow, you can understand.
Sorry, ma'am.
Don't jump like
Sorry,
that.
sorry.
This is a debate.
Sorry, ma'am. Your lordship got it, running page 4.
Satisfied. After such a summary inquiry, as it is proper,
May I
in the circumstances of the case, that any member of the jury was prima facie guilty of moral turpitude is violent sexual activity. Or intimation of immoral sexual behavior of the person. He can terminate the services of that employee for giving 1 month or 3 months pay allowance according to the employee is temporary or permanent to the service of. If he is a permanent employee, then 3 months notice, 3 months salary.
Man.
If not
Temporary,
permanent,
then 1. Temporary, 1 month salary.
temporary is 1 month.
He is permanent employee. In this case,
Procedure for holding inquiry for the major penalty. In such a case, inquiry need not be held also.
prior to the Avinash Nagra case on the year of 1997, there was no inquiry, no so-called reply was required by the authority. When Avinash Nagra case versus Navodaya Vidyalaya came to the apex court, there the apex court in interim directed to the Navodaya Vidyalaya to give the show cause. And give, after the show
Now it is required.
now it is on the basis of which is from 97 to till date, or apex court as well the different high court, this law is accepting by the apex court, which is a settled law, which is accepted by the apex court in subsequent judgment and by the different high court till 2024 also confirmed the article 81B by this honorable high court. In 22 also confirmed that.
You did not answer again.
By giving the show cause. By now giving the show cause after 97.
That Avinash Nagra.
Avinash Nagra case. This is the judgment copy. I have come with that judgment copy with flag mark. Also, your lordship knows all the well versed with all the judgments of the Supreme Court and the High Court. Only assisting to your lordship, subject to your lordship correction. May I provide, my lord?
Do you have a junior with you? You bring one junior beside you. Controlling.
In the Avinash Nagra, after Avinash Nagra case, then my lord,
Whether inquiry was held in the matter?
my lord, preliminary inquiry.
We are asking you. All right.
Yes.
On what grounds the tribunal has set aside the order of the disciplinary inquiry and the appellate order? What are the grounds?
That is only on the ground of stare decisis of the judgment of the settled principle by the Calcutta High Court, on the ground that the department has not acted as per the Sexual Harassment Act of 2013.
Slowly. So there is after Visakha, Parliament has enacted a legislation. That legislation you have not followed is the reasoning of the tribunal.
That is the reasoning of the tribunal.
Is it your case that that act need not be followed? We will follow our bylaw.
Absolutely.
That's the case.
Absolutely.
Let us go to the reasoning part of the tribunal.
My lord, that is running page 113.
113
of my writ petition.
What 113?
Starting from 112, 38.
You said about a date. Let us see that.
My lord, well, I have already. My lord, I have everywhere mentioned. But para 38 of the judgment order passed by the land tribunal, my page running page 112.
Yes.
And I am mentioning para 113, last portion, that I have already stated that. Therefore, the decision of Honorable Apex Court relied on by the respondents are distinguishable.
So matter is remanded for consideration afresh for holding inquiry.
No, not reminded in at last he has directed not remanding. Instead of remanding the matter, the respondents are hereby directed to treat the applicant to have been continuing in the service from the date of punishment till attaining the age of superannuation and granting him in his entitled retirement dues, treating the aforesaid period as duty for all purpose except pay.
Kindly come to 29, page 29, slowly. Slowly, where are your brakes? You have left your brakes in the brakes and the speed breakers at home only. You bring them. Go to para 39, at page 113, rock bottom.
113. Para 39 in the particular fact. In the particular facts and circumstances, we find that this is a fit case where after quashing the impugned orders of punishment, the matter ought to have been remitted back to the authority concerned for causing the inquiry through the committee in accordance with the Sexual Harassment Women's Workplace Prevention Residential Act 2013, but taking into consideration the very fact that allegation relates to 2016, the exoneration of the applicant in the criminal case, and meanwhile the applicant reached the age of superannuation while quashing the order of dated 28/6/2021 and 27/22, instead of remanded the matter, the respondents are hereby directed to treat.
No remand.
Not remanded. My case before Lordship, my lord, the judgment where the land tribunal ratio decidency state decision of one Nirola, which has been the Honorable Appeals Court stayed on 4/3/2022 in SLPC 3241/2000 as absolute stay order, which order with me. Stayed the order of the Honorable High Court of Calcutta, passed in Pawan Kumar Nirola versus Navadha Vidyala Samiti. That case itself, the sexual harassment case where the Article 8(1)(b) was not accepted by the Calcutta High Court, accept the Sexual Harassment Act 2013 because that was not taken into consideration by the Navadha Vidyala. But that order is absolutely stayed by the Honorable Appeals Court. Therefore, as you also know, in 1992 year 1439, Sri Chamundi Moped Limited versus Church of South India, when the Appeals Court grants stay of the operation of the High Court judgment, the enforcement of the judgment is suspended. Therefore, the judgment already in 2022
We'll come to that one now. Now, let us read the act.
My lord.
Is it your case that act is not applicable? We have to follow our rules, our code, and therefore order of the tribunal is wrong. That's your argument.
And that,
let us read the act now. How the act reads. Do you have another copy? Do we have?
He has quoted all the acts by in the tribunal's order. He has quoted, the tribunal already quoted, and only 2 points he has taken, that you have not given the member outside the teacher in preliminary committee and summary committee. But ignoring that, we have given the outside member.
Let us see the act.
My lord, I have given the book. And in 2017 and 2024, 2022, Article 81(b) was confirmed by Honorable Appeals Court as well as this Honorable High Court. That is quoted. That is quoted 4. Section 4. 4 is quoted.
Sexual harassment of women at workplace prevention.
That is running page 100. Quoted in running page 100, that is quoted by the order. In order already quoted by the tribunal.
Yes.
Running page 100.
Perhaps this matter will take some time. Those who want to go for a round, they can. Is there any judgment of any of the high courts in the country or of the apex court or any central administrative tribunal holding that after the act has come into force, all such cases should be treated under the act, not under your employment rules, standing orders, bylaws, regulations?
That is
Which is
judgment.
which judgment?
Under article, that is judgment, my lord. May I provide, my lord? In 2020, data.
But which judgment considers
Not
this
the-
question?
My lord, I'm giving. This judgment I'm providing. Copy. That is the judgment of the apex court.
What it says?
My lord, provide.
Which year judgment?
2017.
17.
Flag.
Considering this act,
My lord, article 18B.
after considering the act,
That was not was the point. That was not point in the case.
therefore we are asking.
Only in the Pawan Karan case. Bas. Only in the Pawan Karan case and the Calcutta High Court. Prior to that, no.
What Calcutta High Court said?
Calcutta High Court said, my lord, that is also judgment. B. Flag B. Calcutta judge which has relied on. B and C relied by the tribunal.
So you don't want to say what
No, no,
Calcutta High
first
Court has
question.
said?
My lord, that said that the article 18 bill will not applicable, only the act 13 will applicable for the KBS employees. That was said, that was the trade by the office.
Which paragraph?
Second copy, that will be second. With paragraph. My lord. Those more computers. Those. B, flag B. Flag B is the point.
This judgment has been stayed by the apex.
Apex code, that is the stay order in the flag A. Absolute stay order till that pending. I have searched from the net till the case is pending. That is flag A. And that is the flag B is the Pawan Karan Nirala, which was the only in this case sexual harassment case article 18B was not accepted. Only prior to that.
So the Calcutta High Court holds you should conduct an inquiry under the 2013 Act. That judgment is stayed by the apex.
And article 18B judgment I have given in 2024 after the Pawan Karan Nirala judgment of 2024 Calcutta High Court. 2024 this Hon'Ble High Court confirmed in the case of Mohammad Iqbal versus Kendra Vidyal Sangathan. This High Court confirmed the article 18B of sexual harassment by the Kendra Vidyal Sangathan. In the case of
This High Court.
This High Court, two
What is
cases
that?
in 20. That is flag. I have given the judgment. That is flag.
C. No?
No, flag C. ABC is the.
Then which one?
My lord, that is flag 4.
Oh, another.
The batch of two cases. That I have
Give it.
flag 4. Now 2 copy I have given. My lord, 2 first copy and second copy.
What this court said?
Says that all the judgment of the appeals court related that the article 81B confirm after the preliminary inquiry. Once preliminary inquiry is there, summary inquiry is there, show cause is given, reply was given, personalization is given, then confirmation Article 81 is, and because in this judgment, moral turpitude.
You are threatening us from putting the question. You are not allowing us to put the question also. Why so much anxiety? Be slow. Go in first game. We are not in a race. Whether this court consider application of 2013 Act.
That was not Article 2013 Act was not the
You will
point.
not hear also.
No.
You wait and hear, then answer.
Not.
You wait and hear.
Whether the coordinate bench in the decision which now you have cited and furnished it to us, the application of 2013 Act is considered.
Not
considered.
Not discussed there. I point that by the applicant also not, that was the point before the tribunal, or before the Hon'Ble High Court. Therefore, that was not discussed nor considered. 2013 Act was not by the, before the tribunal, not before the High Court by the petitioner. Therefore, that was not the point in that judgment.
Now, tell us the grounds on which you want to challenge. Your first ground is, first ground of challenge is
the tribunal committed a gross error
by following Calcutta
judgment
which was stayed by the apex court.
Apex court.
First
This is not. Second is
second ground.
Second ground, my lord. The tribunal failed to the taking into consideration the preliminary inquiry committee where the one of the member is the outside of the teacher, that is NGO member. That was not taken into consider. That is in the preliminary committee, there is a NGO member also there.
In the preliminary inquiry
Committee and in the summary.
1 second, don't jump. Preliminary inquiry is done whether with the participation of the employee or without participation.
With the participation with the employee. He has participated and also given the
preliminary inquiry report is dated.
Madam. that is dated, my lord, 23/12/2016, 23/12/2016, running page 282 to 284 of the writ. 282 to 284 of the writ petition. The preliminary inquiry committee submitted its report to the Deputy Commissioner KBS.
In preliminary inquiry, who were the members?
My lord. Total 8 members there. Well, I'm giving that has filed the member list. Eighty Mr. Principal, Arthatrana Mr.
Wait, panel consists of me. That the tribunal grossly evident in founding its impugned order on the basis of Calcutta High Court judgment, which has been since stayed by the ethics board. Secondly, preliminary inquiry committee inter alia included an independent outsider,
Lady Parents member of Vidyalaya Management Committee.
and such inquiry was held with the participation of the employee. Therefore, in substance, there was compliance with the Section 4 of the 2013 Act, among even others. Thirdly, there is no need to follow the procedure prescribed under the 2013 Act, since the provisions in the Kendriya Vidyalaya Code in that regard are self-contained and self-sufficient. First of all, it was a case of dispensing with inquiry that eventually resulted into termination simpliciter. You have paid 1 month's salary.
Because of
We are asking you,
yes, ma'am.
have you paid
Yes, ma'am.
with payment of 1 month's salary in lieu of notice? Any other point you
My
want to
lord,
say?
that your lordship has asked the question where page number 288 where the member the order
Yes,
of
they have noted.
my lord.
Okay.
And another in the summary inquiry also another member of the NGO member is there. That in summary
In
inquiry.
the final inquiry, also an
One NGO
independent
member.
outside member was comprised by the committee. First of all, well, an inquiry report was made on which date?
Summary inquiry included that is 11/2/2019 inquiry committee at regional level of the 4 members, including a lady NGO member, that is considered on 11/2/2019.
Constituted on 11 to 2019.
Mine.
Submitted report.
Submitted on 22nd 10/2019. My lord, that is the 25th 3rd 2019.
25th
March 25/3/2019 25th March 2019 read running
was submitted.
summary inquiry committee submitted before the deputy. That is running page 341 to 357 of my read petition. Date chart I have mentioned everything in my date chart. Serial number 14 of my date chart.
All.
My
Any
lord,
other ground is there?
that ground, he has taken one ground before his lordship, the P1 teacher, and before the tribunal, that he was acquitted by the criminal court. Acquittal order passed.
Is it honorable acquittal?
That is not, that judgment I have, your lordship's judgment I have come with that.
Yeah.
Not honorable acquittal, because all the
So
informant,
you say no on the.
no.
The acquittal order is dated what? In a criminal case it is.
My lord, that is,
Page number in your compilation.
my lord.
You have not annexed it.
Yes, honest.
Which?
That all, everything is honest. I mean, that is 185 page. He was honest in the way, I have entire way I have filed 185, running page 185.
Yes, sir. Run to 185. 185.
185, running page from 189. 189 running page.
This is
By first.
ER number 5.
Mile.
16.
Mile. And the paragraph mentioned by the session judge, first track, I am mentioning 189 page. She denied to have remembered what had happened with her on the date of occurrence and what she had stated before the police. In view of such, she has stated before the magistrate. She failed to remember what she has stated before the magistrate. In view of such evidence.
Wait. Second good. 39 feet. Is it not a case of honorable acquittal?
No, because he has all the witnesses are hostile.
The Ramlal is followed. Did you cite Ramlal?
That, my lord.
Did you cite Ramlal? Do you know there is Ramlal? You know?
I have followed your lordship's judgment.
Even in our judgment also we have referred to
I refer to Karnataka High Court judgment as well.
We have referred to that Karnataka High Court judgment which is that P.V. Rudrappa.
That I have given a flag 14. Your lordship's judgment I have given a page for flag 12. Your lordship's judgment at para 12. Flag 12. Flag 12, last flag of the judgment. Flag 12. Word and phrases. Your lordship decided honorable acquittal. The concept honorable acquittal is easy to say but difficult to employ. There being no statutory definition thereof, more particularly in the IPC, CRPC in Indian Evidence Act. And at para 6, your lordship elaborately while discussing referring the Karnataka High Court judgment, you also
Come to page 392. 392. Read when it is said to be honorable acquittal.
12. Your
Para 6.4.
Man.
6.4 of Dharmapada Chadai. Ghadai. Go to that Dharmapada.
My lord.
Come to 6.4.
Man.
Read.
Since the grounds of honorable acquittal was...
Where are grounds, sir? There is only ground.
Man.
Why are you adding something to our judgment? Read properly.
since the ground of honorable acquittal was passionately pressed into service, a little more deliberation in this regard is undertaken. The concept of honorable acquittal easy to say,
Easy to say.
but difficult to employ. There being no statutory definition thereof, more particularly in the IPC, CRPC and Indian Evidence Act, Lord William J.
Full stop.
There is a full stop, na?
Nothing is applicable to him. Yeah. Lord Williams, so and so.
My lord, J. In Robert Stuart Wangchope versus Emperor, observe, the expression honorable acquitted is one which is unknown to court of justice. Apparently, it is a form of order used in courts martial and other extrajudicial tribunals. The idea of honorable acquittal is not easy to define, although it can be illustrated by Karnataka High Court decision in P.V. Rudrappa versus State of Karnataka. If an accused is discharged at pre-trial stage or the criminal proceeding launched against him is quashed, there is no difficulty in treating the same as cases of honorable acquittal. For the limited purpose of disciplinary inquiry, a case of honorable acquittal may arise when, after trial, the criminal court orders acquittal with any of nearly following observations: that accused is falsely prosecuted to seek vengeance or for such other ulterior motive, that there is absolutely no evidence or very little evidence on record to implicate the accused in the criminal case, that the prosecution has miserably failed to prove the charges against the accused, that the prosecution witnesses are unworthy of any credence and their version does not generate any confidence. Applying these parameters,
Which is that, let us go to the criminal court judgment.
Para 11, come to para 11 of that.
mile.
Yes.
Viewing in para 11.
Yes.
Running page 190.
Yes.
Viewing in totality and taking into account the testimony of the prosecution witnesses as narrated herein above, no criminality is found either in the evidence of the victim or in the evidence of our parents and brother. As such, this court is of the considered opinion that it would be fraught with great amount of risk to mount accusation on the accused. Hence, this court is of the opinion that the prosecution has miserably failed to bring home any of the charges leveled against the accused beyond all reasonable doubt. Here, all
then it fits into that Dharmapada. This observation fits into Dharmapada.
Honorable acquittal is there.
In Dharmapada, we have laid down as many as 5 plus 2. 7 circumstances where a criminal court acquits the accused, even if the judgment does not use the word honorable acquittal, still the employer can say it is a case of honorable acquittal if it fits into one of the silos. One of the 7 silos, 5 named, 2 explained. It fits into Roman 3. Roman 3 of Dharmapada. Kindly see. Go to Dharmapada 5.4, 6.4. No criminality. Last sentence also. Very clear. Where is the case for you? Read first. We spend more time in educating the members of the bar.
That the prosecution has miserably failed to prove the charges against the accused.
Miserably failed to. Then it fits into 3. Dharmapada 3.
My lord, that this judgment, this In the case of Commissioner of Police and Mayor Singh, in the year of 2013, the Honorable Appeals Court has flag 11, I have mentioned, I have quoted, that is if the 2 or 3 witnesses are hostile. Here,
That is, we are not hostile at this.
all the witnesses are hostile.
That is for the criminal case. Now, the learned judge has
That
said,
is not treated as honorable acquittal, that is the
failed
Appeals Court has
to,
said.
prosecution has miserably failed to prove the charges against the accused.
My lord.
Any other ground? All right, leave it now. We'll treat it. Go to
Fine.
the next point.
Therefore, that acute, and I have given a judgment that acquittal also not applicable to the departmental proceeding. That judgment I have given, that the independent department can take a position.
Understood.
That is Bharat Sanchar Nigam versus that judgment at flag 8.
Yeah.
And as well the latest judgment I have given the Appeals Court judgment also, that
Counsel submits that though the OP was acquitted in PR number 5 of 2016 by the order dated 30 September 2021, there is no bar for holding the disciplinary inquiry in view of Bharat Sanchar Nigam Limited versus
that is the Sima Sarkar versus Bharat Sanchar Nigam Limited at flag 8. And another judgment is Shashi Bhushan Prasad versus Inspector General of CISF, that is Appeals Court judgment of 2019. Where the court has,
if you permit, we'll ask him other questions. Any other ground do you have?
that another 2017, the Honorable Appeals Court has flag 3 confirmed the judgment of the Article 81, confirmed the judgment of this Honorable High Court. Therefore, the Honorable Appeals Court only confirmed in the 2017, Article 81 also confirmed by the Appeals Court in 2017. That is flag
That
3.
disciplinary inquiry can be dispensed with.
Well,
That is the ground.
dispensing with and in that case, the tribunal, the Honorable High Court stated that everybody has their parameter. The teachers has to also their parameter. That was confirmed the Appeals Court because of this is the
Understood. Now, where is the order, acquittal order is considered by the disciplinary inquiry?
well, that is taken acquittal order by the appellate authority considered. But
Disciplinary authority?
by that time he was not acquitted by because tribunal.
On 28/6/21 there was order.
My lord, because he was came to the applicant.
Subsequently.
No, came to the High Court and obtained the stay order of the disciplinary. When vacated the stay order, the punishment order is issued.
All right.
That is in the details I mentioned in my date chart.
All right. Any other ground do you have?
That is my ground. Article.
If you permit, we'll ask.
My lord.
Yeah. Yes, sir.
He has given me so much of judgment, my lord. I'll be.
No, he's doing his job. He's committed to the cause of his client. Maybe his style, our styles may vary. Our style may not be acceptable to you. Your style may not be acceptable to someone else. That is very possible. But he has done a lot of research.
Yes.
He has come to court after doing a lot of research.
I have seen, my lords, very few people can go for such research as he has done.
Yes.
Those research works have no application to me. I have got only 2 points, my lords, to reach, so far as these submissions are concerned.
How tribunal is justified in banking upon decision of the Calcutta High Court, which has been since stayed?
That part I am to verify. Because
No, he has produced it.
my lords, he has given me a copy.
No, we are convinced. No.
All right.
On that premise, you have to make the argument.
I am not on that.
You give up that point only.
Yes. I'll not give up. I'll add it up afterwards.
Okay.
On the very same allegation which was raised in the proceeding, a criminal case was initiated.
You mean to say criminal case is a matter of, it was an order of honorable acquittal.
Yes, ma'am.
But that came after the disciplinary inquiry was held. Disciplinary inquiry was held on 28/6/21.
Yes, ma'am.
Criminal court judgment was entered on 30 September 2021. And as on the date the inquiry was held.
That cannot be called with the dates. After the acquittal order was passed, in my appeal, I brought this matter to the knowledge of the appellate authority. Appellate authority did not consider the same, passed the order of approving the order of the dismissal authority, the original.
Did not consider or rejected. What is the difference?
Nothing has been considered on that.
In the appeal also.
Yes, my lord.
But he said appeal considered the matter.
Let us see.
the order.
Let us see.
Let us go to the order.
Yes, ma'am.
Next one. Government Council appearing for the OP employee submits that. Although as on the date the disciplinary order was passed on 28/6/2021, the acquittal order was not there, matter was taken in appeal before the departmental internal appellate committee, appellate authority, and acquittal order was pressed into service.
That is on page 415. Appellate order.
He says that this aspect of the matter has not been discussed by the appellate authority at all. Yes.
So that is so voluminous.
415.
Upgraded.
This was dated minus 27 or 21.
27.
27/4/2022. After my acquittal and after I communicated the acquittal order,
That is paras 16 of running page 422, paras 16, discussed by the appellate authority. Additional representation, he has filed along with the additional representation that was taken into consideration by the appellate authority as paras 16, details discussed.
Why is not moving? Paragraphs are not moving.
the observation is para 18.
Go to para 16. No, that's Leave it there. Don't touch now. We'll operate. Where is the consideration of acquittal order?
That is para 70.
Paragraph
70.
What is where is the?
I don't get in para 17, there is nothing.
There are 17 only saying a criminal case. Except that, where is the consideration that he has been honorably acquitted?
Then Roman 2.3 next page, 14423. 2, 3, 4. Roman 2, 3, 4 he has discussed.
Two, it is not. Three also not discussed. 4 also not discussed. Where is the reference?
Three, my lord, three. The aberments made in his request,
Where are you reading?
that is Roman 2,
Roman 2, not
post,
3.
no, my lord, Roman 2, post, page 423.
Read.
The aberments made in this request has no relevance to this issue because it is a case of moral turpitude involving moral sexual behavior of a teacher towards girl students, and the same was dealt with under the special provision of Article 81B of the Education Code of Kendra.
Where is the consideration of honorable acquittal?
That was after discussing, that was the findings of the appellate authority.
That word, that
honorable
term
word
itself is not mentioned
not
in the whole of the order.
honorable.
He only says both the criminal case and disciplinary proceedings can run concurrently, independently of each other's effect, the things will happen. That is not his case. His case is, I have been tried. So many witnesses have been examined, including the victim girl, her parents. Then the court entered a finding that the prosecution has miserably failed in proving the charge. Where is that treatment? There is nothing. Petition is dismissed on the following ground. The first contention that the tribunal committed error in banking upon Calcutta decision when the same is stayed with the apex court, where the main matter pens, is still personal. However, even without reference to Calcutta judgment, the order of the tribunal is sustainable on its own merit, inasmuch as the jurisdictional criminal court in TR 5/2016 has entered an order of honorable acquittal on 30 September 2021, wherein paragraph so and so reads as a first one. Though this acquittal order was not there when the removal order was passed by the disciplinary authority, the appellate authority before whom this acquittal order was produced has done only a lip service without due discussion. First now, the appellate authority proceeds on a fundamental principle that the criminal proceeding is different from disciplinary proceeding, regard being had to the nature of consequences, the quality of evidence rendered, and such other things. First, that is true. First, but an appeal being continuation of the original proceeding, that too it was first appeal, the appellate authority should have discussed as to the acquittal order being one of honorable acquittal after the full-fledged trial. First, the victim girl was examined as a witness, and her parents too. First, there was other evidentiary material which learned district judge, having weighed, has entered an order of honorable acquittal in the light of Dharmapada. Second, first, remove honorable acquittal. That order needs to be treated as honorable acquittal because of observations of a coordinate bench of this court. By this bench. By this bench. In at para 6.4 of Dharmapada, which reads as under. Next paragraph. As already observed above, we do not have any quarrel with the proposition that a disciplinary inquiry is one thing and criminal trial is another. Which aspect has been discussed in P.V. Rudrappa? But however, that is not the case in its jugular vein. First, and it, the OP has demitted office on attaining the age of superannuation on which date he retired?
Minus 21st. Total in the month, sometime in July 21st.
On 30th.
It cannot be 21st.
Superannuation was on 30th 2000.
All other than constitutional authorities
6 2020.
retire on last day of the month.
Yes.
30th of June.
30th 6 2021.
30th of June.
On 30 June 2021. And almost 5 years have lapsed since then. First, courts have taken the view that was there any other complaint against him?
No, my lord.
No
25 years, no complaint.
Courts have taken the view that a person who retires after putting in long and spotless service of service,
35 years.
here it is 35 years, should be permitted to be at peace in the evening of his life. First, ordered accordingly. And that will is also correctly.
Weekly list item number 28.
28.
No, sir. I was just making humble prayer subject to your lordship's kind convenience. It's taken up next week. So I've informed the other side, Mr. Mark.
From the other side also?
I've informed the other side.
Next you get the request.
Item number 20.
Weekly list. Weekly list.
20 weekly list. Much obliged.
Yes.
Item 17, Read Appeal 2753 of 2024.
May I please, Your Lordship? The appellant was selected and joined as junior stenographer.
Drag your mic. Yes.
The appellant was selected and joined as junior stenographer grade 3 in government in the office of the Chief Engineer Electrical Power Project in 10/7/1991.
What is the case?
My lord, case is inter-seniority between the present petitioner and private appellant and respondent.
Seniority.
Inter-seniority and promotion, my lord.
Promotion is a seniority cum merit or selection?
Seniority comment
Seniority cum merit. Your initial appointment was as?
was 10/7/1991.
As junior stenographer.
Junior stenographer in government. Office of the Chief Engineer Electrical Power Project.
Appointed on temporary basis as junior stenographer in the office of the executive engineer.
My lord.
Executive engineer.
My lord, in the office of the Chief Engineer Electrical Power Projects, that is Planning and Coordination Development Department, Government of Odisha.
This is pursuant to selection process.
My lord.
After selection.
My lord.
In the select list, where were you figuring? As against those you claim seniority.
No, it is not like that.
Neither.
Not like that.
It is At the time of,
in 95,
of the condition was that you will have to appear for the stenography. Yes.
in 91, I was appointed in government. In 95, Electricity Reform Act came into force.
Oh, even at the time of your appointment, what is the method?
Selection procedure maintained.
What is that selection?
I'll reply, my lord. That is here is not relevant because subsequently
We want to know.
that is selection procedure maintained.
That is how I told you
My lord.
that it is on the appointment order itself mentioned.
Since it is stenographer, my lord. Stenographer typing test was made.
Annexure 1.
My lord.
Condition 2.
Page 24, my lord.
Condition, what is that condition?
It is government of Odisha, my lord. Appointment was initial made government of Odisha.
That is not say.
My lord. Thereafter, in 95, my lord, Electricity Reform Act came into force. 1995.
Electricity Reform Act. Parliament.
1990.
My lord.
Parliament.
My lord, Act.
1990.
As per the my lord.
So from Orissa State Electricity Board,
my lord,
it came to Gridco.
Gridco, my right.
Grid Corporation of India Limited.
I was transferred to Gridco. In 23/7/96.
(23/7/96).
And my lord, when I transferred, private opposite parties never joined in Gridco, private respondents. When I transferred, initially 91 and 96 transferred to Gridco, at the relevant time, private.
He was not born in the cadre.
Private respondent was not born in the cadre.
Private, only one respondent?
No,
how many?
4 to 9, my lord.
4 to 9.
My.
They came to the cadre when?
In 98.
How?
Because of selection.
Directly by Gridco or what?
My lord, Gridco.
Directly by Gridco.
Guided by Gridco. And the interview committee, the present petitioner was one of the member.
What happened?
How that is?
Because typing test should be.
That is what I told you at the very first instance, and you did not see. I told you that that was the condition. If you pass in the stenography, then you will be taken. That was the condition in your appointment. His appointment is
subject to
the probation for a period of 2 years with effect from such and such. If during the period of probation, he will have to pass a test in Oriya typewriting and stenography conducted by heads of department before the end of his normal period of probation.
That was conducted and I have passed.
You passed within the stipulated time. These people came to be appointed, these persons came to be appointed in
April 1998.
Yes.
Because on 7/8/97, letter was issued to the present appellant to be a member of the selection committee in which the respondent 4 to 9 were participated in the selection process.
Your client was a member of the committee.
Member of the committee because
selection committee.
Selection committee because of typing test is taken from the private respondents who participated in the process, selection process.
All right.
They were appointed in 1998, April 1998.
So because your client had already gained experience in stenography,
my lord.
He was taken in the committee.
My lord, I filed the petitioner and other 26 persons. Petitioners and other 26 persons filed original application before the tribunal.
OA number?
That is OA number, my lord.
Why you went to
challenging my absorption in Gridco.
Your absorption?
My lord.
They should not have absorbed.
My prayer was I should be in the government. I should not be
In Gridco. Was there any option?
Thereafter, the Gridco and the government permitted to withdraw the case and we will observe permanently in the Gridco. Subsequently, we withdrawn the case.
No, whether OSCB and Gridco both were going together, both the establishment.
No,
Then
separate.
OSCB is abolished
My level is
and Gridco was taken over. All right, the entire employees of OSCB was taken over by
Gridco.
So when Gridco absorbed you,
My lord.
you disputed it.
My lord.
You wanted to be in the government.
You wanted to be government. Right. Thereafter, the government.
In which establishment of the government?
Government in the energy department.
Energy department.
Electric department. My lord, that the subsequently government.
You withdrew that OA.
I along with 26 withdrawn the case.
OA
number, my lord, 1430 of 96.
withdrawn on
13/12/2002, my lord.
12. 2002,
my lord.
Whether any objections were filed in that? State and that Gridco, any objection was filed there?
Objection filed, they stated that if you will withdraw the case, we will observe permanently in the Gridco.
Where is that?
And they observed me permanently in
where is
Gridco. They observed. Annexure 6 is absorption.
All right. Where did they say, if you withdraw the case, we will absorb you?
Your Lordship, kindly see government order. That is
so that OA 1430 of 96 was virtually for repatriation to your parent department. How you had structured your prayer there?
Your Lordship.
OA.
My lord.
In the said OA,
My lord.
how you and others, it's a joint OA.
Joint OA.
How have you structured your prayer there? Just show that.
Our prayer, even it is not with me, my lord. I prayed, my lord, for absorption in the government. Instead of Gridco, we should be absorbed in the government. Since we are appointed in the government, we should be absorbed in the government.
Not with the corporation.
Not with the corporation.
By which order you were absorbed in the Gridco? Order dated?
Order dated, that is, Gridco post was created. Annexure 4, 3796.
You were absorbed with that effect.
My lord, Annexure 4, your lordship, page 29.
Allowed to remain in charge of the post of chief engineer. So,
last PK Sahu will work under the administrative control. And Annexure 3 minor post was created. Page 27, Annexure 3 post was created. The rank of grade 3 post was created in the Gridco.
Don't change that when I'm reading. Will work under his administrative control.
No.
Where is the absorption?
Gridco administrative control.
No. Till then you have not been absorbed.
No, I have not observed.
Exactly.
My absorption is Annexure 6 at page 31 minute, along with all 27
In
persons.
2003.
Annexure 6 page 31.
2003.
In 2003 with effect from 1/4/97.
From 1997.
From the date you gained the initial entry. Right?
Minor. Initial entry in 96. 96 to 1/4/97 was treated as provisional and permanent absorption was 1/4/97.
Here they have got this of Gridco.
And honorable, with due respect, my lord, honorable single judge held that Annexure 6 is valid, but that is date 5/8/2003. But my retrospective, that was even the pleaded, and honorable single judge pointed out, but in the final order Honorable Single Judge held that decision 5/8 absorption is 5/8/2003.
When order said
1497.
97, single judge could not have said with the other date. Is your case?
This is one of the grounds. And your lordship pointed out, made query, my lord, where the government given assurance for withdrawal, all benefit will be extended. Your lordship, kindly see Annexure 13, my lord. Annexure.
No, your challenge is only to the effective date of absorption.
Date of absorption, on the basis of date of absorption, I should be given seniority and all promotional benefit at par with the juniors.
You have already retired, superannuated.
Retired in 2031 January 2025.
Where on 31
January 2025, ma'am. My lord, 2%.
Why learned single judge altered date?
Lordship, kindly see the findings, ma'am.
No, we are asking.
My lord.
It's your opinion.
My lord. Lord Singular has held that, my lord. Having been absorbed on 5/8/23, 5/8/2003, seniority was duly fixed at that time. Besides, my lord,
Dr. Renuka Prasad versus State of Karnataka. If that date is kept intact, 97, then we will march in seniority.
March in seniority because my lord, private respondent was not born in the cadre, were not born. Besides, my lord, another point is there. One Gauri Jana, also working as a senior stenographer in the government, was also transferred to GIDCO. Both we made.
This is after notice or it is for admission?
After notice.
After notice. Who appears for the other side?
My lord, senior appeal.
I am appearing for OPTCL, that is respondent number 3.
Subsequently,
it was your order which said with 1997, with effect from 97, he will be absorbed.
What happened, my lord? Let him finish for that.
But just we wanted to know. These matters are run of the mill matters. They don't take much time.
In fact, if I order dated 7/8/97, Lordship can say Annexure 8 to the writ appeal, that is page 38. Page 38, Lordship can. Page 38, Annexure 8 to writ appeal. What happens? GIDCO invited 6 existing employees to assist in conducting interview for the post of junior titles. What happened, my lord? He also participated in that interview. The respondent.
Do you dispute?
That's correct.
Do you dispute?
Yes. Yes, yes. We are disputing that 97.
No, I have not said what you are disputing. Do you dispute that Kalinga war took place near Cuttack? So therefore, you should wait till I complete this.
Yes, sir.
Do you dispute that the order which said his absorption is with retrospective effect from 1997 was made by your client? You don't dispute.
Let me plot that page 38. Page 38.
Identical matter was decided by the apex court.
I was not participated. I was the member of the committee.
Ultimately, 5/8/2003 is the seniority was fixed. That is an undisputed fact. 5/8/2003.
the 13 points.
As you can see, this 13.
Pick out AR 1981 SC 1445. AR 2000 SC 594. Facts of this case are very matchable to these two decisions. Same question arose before the apex court. Apex court said, we will now take up the question whether the appellants are entitled to count their service rendered by them as sub-inspector in the BSF for the purpose of their seniority after absorption as sub-inspector in the executive in Delhi police. There the apex court said they are entitled to be counted because other private respondent, they were not born on the cadre. As on the day he got absorbed, because they were appointed in April 1998. Correct?
My lord.
Whereas your absorption was 1997. If that is so, that SI Rooplal versus Governor through Chief Secretary. AR 2000 SC 594 comes to his aid. Because you cannot dispute that you are the author of that order.
That's correct. But my humble submission is before this court is the Lordship can see the 7/8/97. In fact, he appeared for the interview with regard to that is the sin.
After that, these orders have come. It is only after that these orders. So how can you go back now?
That's correct. But
There's no point.
but he participated, but he didn't.
Still you gave him.
You gave him. And rightly.
No, in the year 98, all the respondents spoke to 5 to 6. They selected, but he didn't select.
Question is whether he is selected or not is not the question. You absorbed him. What is the effect of absorption? That question arose before the Supreme Court.
That is one aspect, my lord. What happened? He didn't agree to come into the
That became all history, after this order.
That's why what happened, my lord, he filed in a way. In a way, ultimately disposed of in the 2003.
Very well.
Then subsequently,
you did it, and you assured that we will do it if you withdraw the case.
Now he's a retired person, my lord.
That's all.
With
But
regard
whatever benefit, because once he marches in the seniority, he may have a claim for promotion, etc.
But the Hon'Ble Singh Judge, in fact, he eventually explained all aspects. That's why I say that he had not committed in irregularity. That I
No,
said.
Learned Singhal has stated about the fact.
No, he's very fair.
No. Also finding. The finding also, I agree with the finding of the Hon'Ble Singh Judge. In fact, he has not committed in irregularity.
My lord,
He said that yes, 2003, 5/8/2003 should record seniority with respect to other senator with respect of all respondents prior to that. Hon'Ble Singh just said that. Oh, I agree with that.
No, you are not in appeal.
No, I'm my lord, that's correct.
government directed to give seniority from 1/4/97 to the appellant.
Pursuant to distinction of the government, it is given. This gridco, what is its status?
My lord, GIRCO
Is formed under the Reforms Act.
GIRCO Corporation of Orissa Limited. Only one.
After reforms of 1995, that also the all liabilities are under to OPDCL. My Learned Singhal
2005 रे OPDC आसला. 2005 रे OPDC
OPDCL.
So again, Gridco has transfer to OPTCL. Management of-
all liability and all things are there.
That is what,
Yes.
that means the entire management,
yes, sir.
assets and liability has been taken over by.
All things.
Employees also,
Yes,
Employees also.
including a private respondent.
Respondents and appellant.
Yes, sir.
Then that's a common factor. That's not going to alter the thing. Question is, the apex court said, where long service is entered by an employee, subsequently he is absorbed in another establishment. And those who have been appointed post-absorption, that was a case prior absorption, appointment prior absorption. The apex court said, once he is absorbed, they gain the seniority.
Yes.
Otherwise, you will be wiping out.
This seniority.
That will, and you are doing. Suppose if the rule says, I want myself to be absorbed in a department, then he has to forego the seniority because of conver law. But here is a case where you have absorbed not only him, but other employees also. So as a matter of policy, you absorbed him. You did not give an option saying that you will be absorbed only if your option is been. That's not your case. In a wholesale way, lock, stock, barrel, you passed that order. So he has got a case in the sense, now the learned single judge could not have said that his absorption will be with another date. How can the judge say? When the employer says, this is the date with effect from which we want to treat him as our employee, what business we have got? No.
But another thing it just said because it was page 38, he participated in the interview.
Interview, you have said that. After interview only you have passed this order.
That's why another thing just said that 2003 is the 5-8 to the seniority.
No, that cannot say. He is not working in the judge's
So my
office.
humble submission,
He is not judging as an employee of the. He is not,
since a retired person.
simple to put it metaphorically. He is not working in our quarters. He is working in an independent organization, which is a statutory body. Statutory body in its wisdom says, he will be my employee when Alexander had come here.
Initially,
we have to say.
initially he was in other private organization.
No, government.
Electrical power project.
Government department.
Whatever, he got entry into OSB, Orissa State Electricity Board. Then the entire management was taken over by GRIDCO. Then from GRIDCO to OPTCL. So he has been changing as the government wishes.
And you don't consult him in doing this. You do it because statute mandates, maybe because it is your policy decision.
But in fact, factual aspect, honorable single judge has also explained, and subsequently finding in fact that
No, learned single judge has not referred to the apex court decision at all.
that's
Roop law. Roop law is not considered. Roop law, 100% fact matters.
Ganga Bhisham.
the KK Bardha case and also two decisions are there.
That is a different matter. That is relating to direct recruitment. That decision, seniority of a direct recruitment, madam.
It also in the 97, you participated in the interview and subsequently didn't success.
No, did you rescind that order? The which gave the back service benefit of earlier service. Did you rescind that order? No. And you have assured when he filed OA 1430 of 1996, you told him, you withdraw OA, we'll absorb you.
No, we never said that.
From government.
That is Annex 13.
Government 13. Even then, you absorbed him with retrospective effect. Therefore, how can you say?
Then why did he participate in that interview?
Well, what effect after that? Thereafter, you have passed this order. You have passed this order, which Parudhar pointed out. After the interview, only you have passed this order.
You could have dropped him.
No.
But every they have explained the entire thing.
Any, you want to say anything?
And the only man.
Retired is the retired.
After all, he has retired. Can you be seated? Go to the informed order. This intra-court appeal by a retired employee, go to the informed order of the single judge.
That is page 103, madam.
Seeks to call in question a learned single judge's order dated 6/9/2024, whereby appellant's WPC number 8559 of 2019 having been treated, the relief is molded as a correctly. Go to the operative portion. Just question. Next one. Learned counsel appearing for the appellant submits, and it is borne out by record that appellant was on selection appointed as a junior steno on temporary basis with effect from 10/9/1991. Semicolon.
10/7/91.
10/7/91. 10/7/90. First term. The Electricity Reforms Act 1995 having been passed by the Parliament, Gridco came to be formed, and that the appellant was transferred to the same on 23/7/1996. Correct?
23 or 3?
Observe the dates. Subsequently, the private respondents came to be appointed in April 1998. First term. Appellant and some others had filed OA number 1430 of 1996 before the Orissa Administrative Tribunal, in effect seeking their repatriation to the government for their own reason. First up. However, on some assurance being given by the government, the said OA came to be withdrawn on 13/12/2002. First up. Appellant's services eventually came to be absorbed in the Gridco. Why the order dated? Sit down and answer. It's not a primary school.
5/8/2003.
5/8/2003 with the retrospective effect from
1/4/97.
1/4/1997. First up. Therefore, the counsel contends that the appellant, obviously being the senior to the private respondents herein, the ranking in the seniority as also the consequential promotion on that basis ought to have been conferred on his client. First, counsel submits, this aspect of the matter having not been properly dealt with, there is error apparent on the face of the impugned order warranting interference of this court. First, learned senior advocate appearing for the Gridco and the learned advocate appearing for
I am for the Gridco, my learned senior OPTCL, opinion of
properties. So and so. And learned panel counsel appearing for the Gridco resist the appeal, making submission in justification of the impugned order and the reasons on which it has been structured. First off, learned senior advocate specifically points out that the appellant too had participated in the selection process in the interview, interview, along with the private respondents, and that he was not selected. And therefore, the reasoning of the learned single judge is inexplicable. First one, so contending, they see dismissal of the appeal. Next paragraph. Having heard learned counsel for the parties and having perused the appeal papers, we are inclined to grant indulgence in the matter for the following reasons. A, there is no dispute as to entry of the appellant to the government service with effect from 10/9/1991, 10/7/1991 on temporary basis as junior steno, of course, subject to passing certain examination during the period of probation, which he did. First time. He along with others were deputed to Gridco with effect from 23/7/1996. First, his services along with the companions came to be absorbed in the Gridco wide order dated
5/8/2003
5/8/2003
with effect from 1/4/97.
With retrospective effect from 1/4/1997. That being first, next paragraph. One sentence you have to. There is a unanimity of opinion amongst the jurists of service law that absorption is also a mode of appointment. And it is open to the absorber to make such appointment subject to such terms and conditions as he may deem fit, unless there are rules to the contrary. First of all, the absorption as such is not put in challenge. First of all. Next paragraph. There is force in the submission of learned counsel appearing for the appellant that as on the date his client along with others was absorbed in the service of Gridco, the private respondents were not born on cadre, born in the cadre, inasmuch as their appointment was only in April 1998, that is post-transfer in July, post-transfer of the appellant in July 1996. First off, the Apex Code in Rupal it is, which is actually in SI Rupal versus Lieutenant Governor. AIR 2000 SC 594 has observed as under. First, the absorption order which gave retrospectivity accords with the jurisprudence of this ruling. First one, this aspect having not been duly advocated to by the learned single judge, there is error apparent on the face of impugned order as rightly argued by appellant's counsel. First term. Next paragraph. The vehement submission of learned senior advocate Mr. Das, appearing for the
Respond number two.
Respond number two and three, that the appellant having staked his claim for selection along with private respondents in April 1998 did not fare well, and therefore now he cannot turn around to gain higher seniority ranking in the seniority list for those private employees is bit difficult to countenance. First off, the order dated 23/7/1996 transferring the appellant and others to the GRIDCO was not put in challenge by anyone. First off, added, the order dated 5/8/2007, whereby 5/8/2003, whereby absorption of these transferees happened with retrospective effect from 1st April 1997 is passed by these respondents only. Correct? First off, the Apex Code has held that an opponent cannot challenge his own order in the proceedings launched by the employees. First off, sustaining contention of the kind would run counter to this philosophy. First off, whatever ranking in the seniority list and the consequent promotion ought to have been accorded to the appellant herein needs to be accorded, treating him as having been in service with effect from 1/4/1997 for other similarly circumstanced employees. First off, the fact that appellant has demitted office on 31/1/2025 on attaining the age of superannuation would not silence his rights. And therefore, all that benefit needs to be given to him in the light of Apex Court decision in Rajasthan Electricity Board versus Mohan Law. AR 1950's judgment it is, where deputation was denied. Rest of the people got. The Apex Court said it is violative of Article 4. You take out that judgment. '65, '67, Rajasthan Electricity Board, Jaipur versus Mohanlal. You are right. All right. This is AR 1967, SC 1857. Any paragraph, specific paragraphs, can you lay your hands on? put that. Just look into that paragraph, structure it here, internalize it in the judgment. In the above circumstances, this appeal succeeds. 7. There shall be interference in the alternate single judge's order to the effect that the appellant shall be treated as being senior to the private respondents herein, and on that basis, he shall be conferred the promotion which is immediate juniors been granted, with all consequential benefits. First, time for compliance is 3 months. Cost made easy. Yes.
Item 18, read appeal 851 and 2025.
Yes.
Some of the
It seems a matter. Very
memories.
Then, because last time you argued this.
But your lordship raised a very pertinent issue. What is the basis? What is the source of that 87 resolution? Or which law that has been issued?
Correct. But there is another problem. For undertaking that exercise, first you have to show what is the defect in the judgment. Come on.
No.
Start.
Meaning thereby, Lord, now I can come into the merits of the matter.
Correct. Right. Then we can go to that level.
No, if that resolution stands, then I can raise a claim. If resolution doesn't stand in the face of it, if your lordship take a view that that's not it is sanctioned in the eye of law, then there is no requirement of going into the merits.
Now, as on the day, allotment was made to Madam's client.
No. Allotment was made in my favor in the year 1987.
And you subletted to
70.
No question of subletting it, man. I am in occupation. While I am in occupation of the property, my industry was laid off.
Correct. Therefore, you went away.
I never went away.
You continue.
So you did not continue in the occupation.
That is the point. My industry was laid off. That industrial dispute was raised with regard to laying off the industry. The tribunal passed an award that laying off is illegal. So as a consequence of the judgment, my laying of industry is illegal. As I was continuing, I continued as such that laying off of the industry was held to be bad by the industrial tribunal, and that is the final judgment.
Correct.
And consequently, if your lordship would see that act itself, kindly see, my lord, that in the Housing Act, that protects me in case where there is industrial dispute pending, kindly see, my lord.
Protects you provided you are in the occupation of the structure.
Yes, we are. By virtue of the judgment passed by this court, we are put into possession again. That judgment is here. That's there. Lord, the two issues, Lord. On merits, I'll address on two issues. One, whether I was an industrial worker, as on the day the resolution was passed, 87 resolution was passed. If I can succeed to show that I'm an industrial worker, then I have a point. Second, with regard to the occupation. I was in occupation of the property, this allotment. I was thrown away by application from the other side. That I'll show the discrepancy, glaring discrepancy on face of record itself. He is an applicant in the year 1990. Authorities are saying that he has been allotted since 85. Position. 85. You are applying for allotment in 1990. Yeah. How can you remain in position in 85? That is the glaring defect.
Where you allotted?
Yes,
sir. 78.
In 1978.
Right. I was allotted on 24/9/77, page 68 of my return. Guys.
When the industry was laid off?
It was laid off. It was laid off
one second. My lord, 26/9/1986. That is at page 71 of my writ appeal.
26, 29.
26/9/1986.
And your allotment is dated?
Dated 24/9/77. The allotment was made final on 21 December 1977.
No, allotment is
24/9.
Initially, it was a provisional allotment. Then it was made final on 21 December 1977, page 69.
1987.
77.
77.
Then my employer got bifurcated. It was bifurcated to two industries. Then laying off 26/9/1986, my employer, the industry got laid off. Then it was
Laid off
challenged.
is had to be bad by the labor
That
court.
is
When?
6/11/1986, page 73.
Labor court or industrial tribunal?
Lord, this is industrial tribunal. 6/11/1986 at page 73.
Whether appeal, anything, writ petition, anything was filed?
No,
against
that's
this?
final.
It has attained finally.
It has attained finally.
What was the nature of order?
Kindly see, Lord, page 73. Lord, it starts from page 71. Starts from page 71. It Gazette publication, as your lordships are aware about. The award is published in the official Gazette. Then para 8. Regarding Lord, thus, page 73, thus, there is no material before this tribunal to come to a finding that the layoff was
For the reason.
for the reasons as stated above. As such, the layoff declared by the management must be held to be neither legal nor justified. The workmen, therefore, are entitled to full wages from the date of the layoff was declared, that is 16/8/1984.
84.
84 or 84?
16/8/84. Then the 26/9/86, which you said is not correct.
16/8.
But that is in my list of dates, page 71, or some kindly see.
No, this order itself says na.
26/9.
Order is order.
That is order.
Order.
But given effective 9.
Order is 23rd October 1986 for Gazette publication 6/11.
But then you have written here, layoff was challenged. Layoff written.
16/8/1984.
84 is the layoff. I stand corrected. I stand corrected. I'm so sorry, bro.
No, sir.
I'm so sorry.
The thickness of facts sometimes these things happen.
Then only after this is declared invalid, layoff was declared invalid, 87 resolution comes into force.
What is that 87 resolution?
That your lordship would kindly turn to page 81. Page 81. May I read it, madam?
Yes.
The subject, transfer of tenements constructed under integrated subsidized housing scheme for industrial workers and economically weaker section of community.
This resolution by the government?
By the government of Odisha. Referring to government of India's notification. Referring to the decision taken by government of India. That's why I was placing it, madam. Industrial subsidized housing scheme for industrial workers and economically weaker section of the community was introduced during 1952. The scheme was implemented during the past year 5-year plan. 1270 tenements were constructed by the state government during the period 52 to 53, 64 to 65. As contemplated under the scheme, the state government received 50% of the selling cost of the tenements as loan, 50% subsidy from the government of India. Considering various aspects, Government of India and the Ministry of Works and Housing, by their letter number so-and-so dated 9th of February 1978, have directed the state government to sale, to allot, or what is it?
To the transfer of the mandate.
commenting to. But it's not visible. Sale.
See, come to 3A Roman small 1.
Yes, yes.
Provided further that such a person should be in continuous possession of the tenement
Correct, Lord.
allotted to him.
Yes.
Yes.
Then Lordship would kindly see also 4.
Each case will be examined by the committee so formulated by the resolution for recommendation to government. What the committee said in this matter?
Committee said against me. Referring to that 85, it's completely non-existing aspect. Committee said that he is in possession since 1985, whereas he is applying for allotment in 1990. This discrepancy has just shown to my lord. Kindly see application. Page 84, man. Page 84. This is your application by the Housing Commissioner. Your application dated 30th of October. This is that other side, private respondent. Your application dated 30th of October 1988 for allotment of industrial tenement Z/4. This is the same. At Kapuria Labor Colony compliance so and so. With reference to your aforesaid application read with laid down in 12.5 of Odisha Interception Act, I would advise you to comply with the following so and so for facilitating this. It is only for fulfillment conditions cited above. Your case should be considered. Now his application is admittedly on 30th of October 1980. Kindly see the report. But how can he say to be in possession since 1985? Kindly see, page 89, my lord. This is the report of the Assistant Labor Commissioner. As per your direction, number so and so, I have verified the said tenement at so and so colony. The Sri B.C. Sutta has been staying since January 1985. This is overwritten again. 1985. At present, he is working in so and so.
Well, was he working in that in the same industry?
No, they are different industry. The industry is saying something different, not in the same industry to that of me.
But he is in industrial estate area. He is there.
Yes,
These tenements are meant for only that industry or others also?
Industrial workers.
Any industrial worker.
Different industry.
Any industrial.
Housing scheme or
any industry. Now you are see para 7 of the improved judgment. 7.7. Kindly see, Lord, 7.2 rather.
7.2 of?
The improved judgment, page 57. But on the face of his own application in 1988, can it at all be said that he is in possession since 85? Kindly see, Lord. Then I'll take your lordship to one of the orders passed by this one. Then I'll stop there. As found from record on inquiry, Assistant Labor Commissioner. But you got it?
No, which
running page 57.
57.
Right.
Internal paragraph?
Internal paragraph 7.2.
7. As found from?
Yes.
Go to 7.2.
Yes. 7.2.
Go fast.
Should I?
No, sir. As found from the record and on inquiry.
Assistant Labor Commissioner Patel, by his letter dated 29/8/1989 on Annexure D/5 found that OP number 5 is in possession of Tenement since 1985. Such an inquiry was made basing on letter issued on 21/7/1989 Annexure D/5. Basing on such report made by Assistant Labor Commissioner on Annexure D/5. Rent for the tenement for the period 85 to 87 was accepted for the OP number 5. Annexure C/5.
OP number 5 is yourself.
Him. The private respondent.
I am.
You are OP number 5.
Was accepted OP number 5, Annexure C/5. It is also found that basing on such report, Assistant Labor Commissioner D/5, since petitioner was found not in continuous possession of the tenement and in terms of provisions contained 6C of the Odisha Industrial Housing Act, Rule 12(5)P of so-and-so Rules 1969. Petitioner ceased to be an industrial worker. Allotment of tenement so made in his favor was cancelled by 5/190 on a UI5 by another order dated so-and-so, so-and-so. The tenement was allotted in favor of the OP number 5. However,
Such cancellation and allotment made in favor of the petitioner by the order dated 5/1/90 and subsequent allotment made in favor of OP number 5/5/1/90 was interfered by the in order dated 12/5/1995 OJC 5862 of 91, even though this court by the order dated 12/5/95 set aside the order dated 5/1/90 and remitted matter for a fresh decision by the Tenement Committee, but as found in terms of the said order, the Tenement Committee once again in its proceeding dated 5/7/2002 BY2 to the counter affidavit.
What is that nature of the committee?
That
Who
is
are
in terms
the
of
committee?
87 policy, there is a housing committee. In terms of
Comprising of
labor commission. Page 82.
only one man committee.
Three members.
Three
member committee.
Collector of the district.
Then I take you all through the earlier orders passed by this honorable court. How I was evicted from the quarter and I was restored by this honorable court by indulgence of this honorable court. Kindly see that order. Justice Chatterjee order.
Page 93.
Page 93. Just see page 93. Your Lordship will find how this poor man is being harassed every day. Kindly see page 93. Para 11. That is the allotment referred to by the Honorable Single Judge Melo. A very short point has arisen. Running page 93.
Having heard.
Yes, a very short point has arisen in the instance. Having heard and advocates for the petitioner for the state, including Housing Commissioner, Labour Commissioner, OP number 4, Vishnu Sutar, it appears from the materials on record that quarter in question, tenement number so-and-so was allotted in favor of petitioner Bhaskar Raut in terms of Annexure 1. It is alleged that without determination or proper cancellation of the allotment, order issued in favor of the petitioner, opposite party number 4, has been allotted the said quarter in terms of Annexure 5. In view of such allegation, we had called for records. Pursuant to the said order, entire records of the case have been produced before us. On perusal of the same, it transpired that though an attempt has been made to serve notice on the petitioner before cancellation was done, but actually no notice was served. However, without serving any notice, any act done or cause to have been done to cancel the order of allotment standing in the name of the petitioner in terms of order of allotment is unwarranted and uncalled for. It is, however, submitted on behalf of OP number 4 that he was allowed to deposit area dues for the petitioner, and while in dearth of accommodation as a laborer, the allotment was made. On appreciation of all facts and circumstances, we hold that unless there is a valid order of cancellation, the question of fresh induction is neither possible nor can be supported. The learned advocate for the OP number 4 has very fairly submitted that sufficient time should be granted, and particularly considering question of approach of rainy season, time till end of October 95 should be given to vacate the quarter. Recording such submission, we cancel the order of allotment made in favor of OP number 4. Means the OP number 5 here. OP number 4 in terms of Annexure 5, possession of the tenement should be restored to the petitioner. Thereafter, after opposite party number 4 vacate by end of October 95, it made clear that this order will not prevent the authorities concerned to initiate proper proceeding for cancellation of any act committed by the petitioner after possession is resorted to him. The petition is disposed of accordingly, no cost. It is made further clear that petitioner in OP number 4 will appear before the Commissioner, Housing Labour Commissioner on 11th of October 95 to avoid issue of fresh notice. Having heard, next minutes, having heard and lawyers for the respective parties and considering their submissions, we make it clear that if Housing Commissioner Labour Commissioner has no jurisdiction to proceed with a matter of eviction, as it is submitted that for the purpose a committee has been formed by the government constituting Labour Commissioner as its chairman, the concerned collector of the district under whose jurisdiction tenement are located, or his nominated representative as member and director of Housing Deputy Secretary to the government in the Housing and Urban Development Department member convener. The order stands modified to that extent. We are also convinced of the difficulty of the OP number 4 and time as fixed at the end of October is extended till end of December 95. Order stands modified to the extent only as indicated. Then what after it was demanded to the committee.
Yes.
The committee passed order which was challenged before the Honorable Single Judge Melo. Last committee.
Last committee unacceptable.
Unacceptable. But this is the last committee your subject matter of challenge for the Honorable Single Judge.
Yes.
Kindly see Lord, page 66. There were intervening committee findings that were challenged in appeal, but they are not very much relevant for the purpose. Page 66, my Lord. Now this is the final order that was challenged. As per order number 16.
Why that they say Bhaskar Rao sees it to be an industrial worker after 31,387?
That is the glaring mistake in the committee's finding. You could not have said this in view of the industrial tribunal's order.
Additional evidence.
Lord, if your Lordship would kindly see, Lord, I'll just request my Lords, I have filed certain additional document by of an IA to demonstrate that, Lord, kindly see the orders passed, Lord.
Section 6C, they have referred. Section 6C of the Odisha Industrial
Housing Act
so provides that a person shall deemed to be an unauthorized occupation of any industrial tenement
if he has to be an industrial
worker.
That because of that layoff, and that layoff is declared to be invalid. That is, the committee has not taken that into consideration. And if your Lordship would see IA 4118 of 2025, which I have filed later on, Lord, kindly see, Lord, there are further judgments directing the industry to pay my arrear salary, wages, bonus, everything.
Because of industrial tribunal's order.
Yes. Kindly see, my Lord. 2005. In 2005, Lord, kindly see page 6 of IA 4118 of 2025. That is our flag.
Yes.
Well, kindly see the order. The order is at page 7. The applicants filed miscase on section 33C for computation of area due. My Lords, kindly see hence ordered. Page 8, para 5. This case is allowed ex parte.
Page number?
Page 8, my Lord, of my IA, internal page 3. Flag C, man. This order dated 25th of May 2012. This is IA 4118 of 2020. 4118. Flag B.
Yes, flag B.
33C2 application by the petitioner and other group of employees.
Money due from an employer.
Yes, Lord. Computation of admitted.
This chart.
Kindly see the chart.
So benefit of that tribunal's order is granted to you.
Yes.
That should also include your status as an industrial worker in your submission.
Your Lordship, may kindly see, it is page 12, my Lords, of this IA, kindly see.
Serial number 4.
Serial number 4. Kindly see the column from 114 to 31/10/2005. The dates are here. 114 to 31/10/2005.
And it's received. That's
So it's a page 12.
Yeah.
Page 12.
That is page 12. Come to page
Page 12, serial number 4.
The table. Yes.
Lordship,
This is
see the
serial
dates.
number 4.
Yes, my Lord. Serial number
After
4.
all.
Yes. 1487 to 31/10/2005.
Serial number?
4. What is due from?
Yes.
Now, Lord, there has been an order also to implement that at page 14 of this very same IA.
Which order? The benefits.
Yes.
No, that's not it. How that's going to?
Now, if your lordship would see.
Your first contention is throughout you have been in the possession of the property.
I have been industrial worker. Till 87.
And you are the industrial worker.
Till 87, I am an industrial worker in view of the award and subsequent orders passed.
In 1985, you could not have been in the occupation allot. You could not have had in the possession at all.
Yes.
Is your submission?
He could not have been because your application is 1990. 88, I'm sorry. 88.
But in the application, he said, I have been in possession.
No. Kindly see. He is applying for the first time in 1988.
That is what. But the committee said that it is from 1985.
Yes. When you have
where they have written in by hand, which you pointed.
When you have never been allotted, as per law, if your lordship sees.
Now, you were not seen in picture then. In 85, he was not in picture.
He was never in picture.
Is your submission?
No, my submission is that for that Industrial Housing Act, any possession without a valid allotment is an unauthorized occupation, an encroachment. No premium in favor of an encroachment. Kindly see Industrial Housing Act.
Anyway, that is restored, no?
That is restored by virtue of the Hon'Ble Court's order. I have been restored, and still I am in occupation of the premises. Hasn't it?
You are in the occupation of the property.
Yes.
Pursuant to the DB order, division bench order.
Division bench.
Yes. And by virtue of the interim protection granted in my favor from time to time, before the Hon'Ble single judge and here also by your lords. Kindly see. Kindly see Lord section 6. Kindly see section 6 of Industrial Housing Act.
Please read.
I am so sorry, Lord. I am so sorry.
No,
it's not given to your lordship. Lordship should see.
Yeah.
Section 6 month. For the purpose of this act, the person shall, save as otherwise provided in this act, is deemed to be unauthorized occupation of any house where he has entered into possession of a house otherwise than in pursuance of an allotment made by the Housing Commission. Where being an allottee, he has by reason of cancellation of allotment on section 8 ceased to be entitled to occupy the house or has ceased to be an industrial owner.
Even if he has made payment also, still he will be deemed to be an outsider.
That is similar rule 13 of the rule that each kindly see rule 13, madam. Your lordship raised a very pertinent issue, rule 13. There shall be payable of that rules, corresponding rules.
That page?
That is, as it appears, internal page 7, running page 44. Rule 13.
The rule fixing of that.
Industrial housing rules.
Powers.
That attached to that act itself.
Powers to recover damages.
No. A payment of rent and other dues and the mode of payment.
That is section.
Rules.
Can you see the rules? But this is like this. This is like this, man. But see, people lordships have got it.
Rule number? That we got.
That we got.
Then the relevant
it is 13.
Rule 13.
Payment of rent.
There shall be payable by every allottee of the house or as the case may be, by his employer, monthly rent and other charges to the officer who shall be duly authorized by the Housing Commissioner on proper receipt. The officer credits also within 7 days with the rate of it is only by an allotment, not otherwise.
Possession share with permission of the authority.
No, what for you are reading this, Mr.
No, I'm saying, since they're taking a plea that we have paid rent, or I say that unless you are a valid allotee, any payment of rent will not be sanctified by, it's not accepted under law. Because Rule 13 starts from the word allotee. With the corresponding act is Section 6.
First literate by permission of the authority they entered into the basis.
What you say is even if he has made any payment, even that will not help him, is your contention. Who had put him in possession of the occupation of
By evicting me, authorities put him in possession. That is what was challenged before this one.
That is only during the period the industry was laid off.
Yes,
That is
you rightly got it. After the 87 resolution came in, with a hope that I'll get it settled in my favor.
No, let us see what,
Madam.
Madam.
Can I sum it up now? Just to sum up. One more minute.
Yes.
Lord, if your Lordship would see that that committee is finding, committee has negatived my case. Only one point of I have ceased to be an industrial law. There is no other ground taken by the committee. That your Lordship has seen it.
So by virtue of industrial tribunal's order, that vinculum juris of employer-employee is restored. And it should be restored with retrospective effect.
But if there is any other aspect now submitted before your Lordship, they are beyond the scope of the committee's order because committee has not inquired into any other aspect. Now, the Hon'Ble single judge has, on the face of it, has committed wrong, has committed error of record to the extent continuous possession when the Hon'Ble High or the court.
You can be said.
Yes, I have been put to question that one. Two. The Hon'Ble single judge has failed to take note of his date of application and his claim of possession from 1980, which could not have been done in view of Section 6 read with Rule 3.
Yes. Mr. Rathod, senior advocate appealing for the appellant, seeks to void the impugned order. Kindly be seated on the following grounds. Number one, allotment in his favor is not in dispute, and to a great extent his occupation as well. He being an industrial worker who had suffered laid off order dated 16/8/1984 by the management. Semicolon. The said order came to be set aside by the Industrial Tribunal with award dated 6/11/1986, holding the layoff to be completely illegal, and pursuant to that, all benefits have been accorded to him, whose particulars have been furnished in the form of documents accompanying the application. IA number?
IA number 4118 of 2025.
Yeah.
And this is for the first time in the writ appeal.
Sir, 118 of 2021. First time. Second, even otherwise, the allotment and occupation of the appellant has to be construed in the light of division bench order dated, kindly sit down and tell. Kindly be seated. Just tell the date.
That is dated 12th of May 1995, page 93.
In writ appeal number?
OJC number.
OJC number?
5862 of 1993. 586 of 1990.
Disposed of on?
Disposed of on 12th of May 1995.
12/5/1995. Come on. But how you have begun the sentence?
(1991).
95. Whereunder time was granted to response number 5 to vacate the premises, and the extension was granted on multiple times after placing on record displeasure of the court. First, the said order having attained finality, neither the housing committee, allotment committee or housing committee?
Housing
committee, nor the learned single judge would have recorded any finding that would not go in consonance with the tenor of that judgment. Next paragraph. Under section 6 of the Orissa Industrial Housing Act 1936, who is the unauthorized occupant has been specifically indicated. So, under clause A, no person shall be deemed to be an allottee unless he has been duly granted allotment order, and that would be so even when that person has remitted certain amount as a precondition for gaining entry to the tenement. First one. He also draws our attention to Rule 13 of Orissa Industrial Housing Rules 1916. Yes, madam. What did he say? Now, one more point. He also submits that when the very application of R5 is dated,
application is dated 84, page 84. Application dated 30th of October 1988.
30/10/1988.
And allotment dated 26/4/1990.
And allotment is dated
26/4/1990, which has been set aside by this one.
Which is set aside in writ appeal.
Yes.
It was incongruous for the committee to hold that he was in the possession of property since 1985. First one, this aspect has not been adverted to in the rights perspective by the learned single judge. Yeah.
The issue is from 1995 was relating to the cancellation of the tenement.
Cancellation of tenement.
Granted in favor of the petitioner.
Your client. His client.
Yes. The division bench of this court have set aside the cancellation only on the ground that no notice was issued to the petitioner before cancellation and remanded the matter again for fresh adjudication after giving opportunity to the petitioner.
Let us read the division bench chart.
Right. It is at page.
Yield the place to madam.
Page 93.
Give place to madam. We should use words of seventh standard. Only then they will use. Yes.
Mine.
Yes.
Your Lordship, page 93. The operating portion, my Lord.
Kindly come to having heard. Para 11.
Having heard. Para 11, my Lord.
Yes.
Your Lordship will turn to page 94.
94.
Page 94.
No, read this also. We'll come to that.
Enter. Yes.
Come.
Having heard the learned advocate for the petitioner for the state, including the Housing Commissioner from Labour Commissioner and the opposite party number 4, Mr. Sutar, it appears from the material on the report that the quarter in question, tenement so and so, was allotted in favor of the petitioner Bhaskar Rao in terms of Annexure 1. It is alleged that without determination or proper cancellation of the allotment order issued in favor of the petitioner, the opposite party number 4 has been allotted the said quarter in terms of Annexure 5. In view of such allegation, we had called upon the records pursuant to the said order. Entire record of the case have been produced before us. On perusal of the same, it
transpires
that though attempt had been made to serve notice on petitioner before cancellation was done, but actually no notice was served. Without serving any notice, any act done or caused to have been done to cancel the order of allotment standing in terms of the petitioner, in terms of the order of allotment, is unwarranted and all confirmed. It is, however, submitted on behalf of the opposite party number 4 that he was allowed to deposit the area dues of the for the petitioner while in that period of the accommodation as a laborer, the allotment was made on appreciation of all the facts and circumstances with that, unless there is valid order of cancellation, the question of fresh induction is neither possible nor can it be supported. The learned advocate for the opposite party number 4 has very fairly submitted that sufficient time should have been granted, and particularly considering the question of approach of rainy season, time till the October 95 should be given to vacate the country. Recording such submission, we cancel the order of allotment made in favor of the opposite party number 4 in terms of Annexure 5. Possession of the tenement should be restored to the petitioner. Thereafter, the opposite party number 4 vacate by the end of so. It made clear that this order will not prevent the authorities concerned to initiate proper proceeding for cancellation for any act committed by the petitioner after the possession is restored to him. The petition is disposed of no so and so. By virtue of that, again, my lord, a proceeding was initiated.
Yeah, proceeding was initiated against him for cancellation.
That your lordship will kindly turn to.
So you mean to say this order will not come in the way of such a proceeding being under? In fact, it says that such proceeding should be taken. Is your question?
Yes. And the proceeding your lordship will kindly turn to.
But your allotment is set aside.
Yes. My lord, the petitioner has to prove his case whether the cancellation is bad or good. That 87 resolution is not the subject matter of the proceeding. Not referred to anywhere. No.
Now, my lord, I will show to your lordship the fresh initiation of the proceeding and the result thereof. Your lordship will kindly turn to.
But the submission, the learned advocate for the opposite partner of 4 has very fairly submitted that sufficient time should be granted, and particularly considering the question of
Opposite partner 4 in that case. Sufficient time, yes. Time should be the rainy season.
So that he restored, and if necessary, the fresh proceedings will be held.
Yes. And the lordship will kindly turn to page 119.
So what you mean to say is the division bench order is not end of the matter?
No.
Yes.
Page 119. And the tenement committee meeting was held on in pursuant to the order of this Honorable Court on 5/7/2002.
They reproduced the order.
After proper service of cancellation order, also, and Kapuria colony shall be re-allotted to Vishnu Charan. That is the finding. Both the parties together with the ancillary document pertaining to the following decisions were taken. Following decisions were taken. Appropriate and prompt action shall be taken by the housing collector to cancel the industrial tenement quarters at Kapuria Labor Colony quarter. From the name of Bhaskara Rao, allotted allottee, as Raut was not an industrial worker on the date of the government notification, it is so and so, and for the purpose of so and so, so and so.
1 second. On 24/6/1987, was he not?
That I will come, my lord. After showing the orders which were passed, thereafter I will show to your lordship other facts. Facts, not law, my lord, which was dealt by the learned signatures.
Yes.
After this order was passed, it was challenged in appeal before the learned disputers.
Appeal was
provided in the act.
In the act itself.
And the appeal at page 124.
124.
Yes, my lord.
This is just cut.
This is just cut.
What?
He has confirmed the order of cancellation.
This order is dated. This order is dated.
Dated, my lord, 21/2/2005. The order of cancellation was confirmed.
The cancellation of his allotment was challenged before the statutory appeal, and the appeal came to be rejected. With the finding
the same, my lord, he is not an industrial worker.
Industrial worker.
As on that date. Mr. One small clarification, Mr. Athok. After 6/11/1986, layoff was held to be layoff of 16/8/84 was held to be bad by the Industrial Tribunal. Thereafter, what happened? You have been given the money.
Thereafter, we continued as such. We are claiming wages, we are claiming calculation of our dues, and we applied 32(2)(c). And the latest order I have shown.
33(2)(c).
I'm so sorry.
C2.
The 33(2)(c).
C2. C2 of IDA.
So wrongly I said 33(c)(2) of the act. And Labor Commissioner has initiated content proceeding for implementation of that. Recovery. I'm so sorry. Recovery proceeding.
Under section 29. 29 of the act.
Yes.
Yes, madam.
My lord, it was confirmed in the appeal. Thereafter, my lord, the petitioner again approached this honorable court by filing a writ application.
Matter is remitted. Remitted.
After remitted, again a fresh order was passed.
In the appeal itself.
No, fresh order was passed by the committee.
Why committee?
Another.
That is Annexure 2.
By the committee. It was remitted to the committee, not to the appellate authority.
Okay.
So
it was remitted to the committee for fresh consideration.
Fresh consideration.
after setting aside order of the district judge.
Decisions. Only on the ground that some documents have not been taken into consideration by the committee while deciding for cancellation
Now that committee has held against him.
against him,
And
which was challenged in the writ petition, which is now in the writ appeal.
Oh, he did not file another
Appeal.
appeal before the.
No.
The single judge order went in my favor, remitted matter back to the housing committee again.
Correct.
Housing committee passed an order annexed to holding that since I ceased to be an industrial worker since 87, I have no right. That's why
No, that's all. That order was not challenged in appeal.
No.
Statutory appeal.
That's not available. That's not available. It's not
Not appealable.
Not available.
The eviction
For the
order,
eviction order, sir.
we are claiming settlement, madam. That is our.
That order, the lordship would kindly say.
Where is that appeal provision?
That is, my lord, section 14, my lord. Section 14 of the Act, my lord.
Appeal. Any person aggrieved by an order of the housing commissioner under section 8 or under subsection 2 of section 12 may. What is that order of the commissioner under section 8? What is section 8?
That is confirming the cancellation.
So appeal is maintainable.
Yes.
Yes, cancellation of allotment is appealable.
Eviction.
Now the posting of a settlement pursuant to the 87.
Lordship may kindly see. It's a
Unless cancellation order goes,
kindly see.
settlement, how settlement will come?
Kindly see the order passed by the committee. जो first demand for order करें.
No, that includes that the 8.
There are two aspects involved.
An appealable order also. You may have some explanation as to why appeal was not preferred is another thing. But it is appealable.
Kindly see the order passed by the committee. After the first remand, kindly see the order passed by the committee. Same day allotment, same day cancellation. Kindly see.
Committee cancel the allotment.
Kindly see page 123.
No. That is the result of the committees. Committee has cancelled the allotment. It was that page what my senior brother is showing.
Brother,
That is, my lord, pursuant to the order of the committee.
Kindly see
Collector has issued that you vacate.
Okay. Not the committee order itself.
No.
Kindly see 121.
120.
Let us be not confused on facts. Kindly see page 100.
This is committee proceeding.
Right. That is the order we challenged before the earlier case. After properly service of cancellation order on Sri Raut, partner number so-and-so at the said Kapuria Labour Colony shall be reallocated to so-and-so an employee of Odisha Instrument Co. Industrial Cutter who shall be instructed to deposit unpaid house rent so-and-so, possession of the industrial tenement so-and-so which was given to Bhaskar Raut previous allottee shall be taken back by the RI so-and-so so-and-so. Same day cancellation, same day allotment.
No, that may be a ground for appeal. But
They have prepared appeal.
Against this also.
Then against that order of Tenement Committee passed on 5/7/2002, they have prepared appeal. That I have shown to your lordship.
Earlier.
That is showing.
What is applicable? Kindly see 121. 121. If you are making a comment from
Mr. Ratho, this is 16/8/2002.
This is the order. Eviction order under section 12. Kindly see below 121. This is a consequence of the earlier order. This is appeal.
Eviction order is applicable, but the
any order passed by the committee.
No, any order. That order said what?
Any
claim for the committee, since after 1987, there is no scope of continuance of tenement. Only one scope for the workers under 87 benefit. Under the 87 circular, tenement will be settled in favor of the worker. This is the committee has to take decision on settlement. That is our application.
Not a cancellation. It's an issue of settlement.
our application before the committee for settlement, that is the prayer, that has not been taken note in the settlement.
Kindly look at our prayer, madam.
In the committee, page
Page 158. What is our prayer before the committee? This is in terms of that 87 circular, we have applied for settlement. Now the committee has rejected it. That is not applicable.
Yes. Yes, madam. Understood.
Well, again, it was cancelled by the committee.
I am taking more time because such a loss in our state, the state from which I hail, there are no such legislations. Therefore, new legislations.
Really grateful. After your lordship raised that pertinent issue on the past day when I started argument, I went to Ranganath Reddy. I went to Sanjeev Kaur. Those judgments, your lordship referred to in another case, that natural resources.
33B.
Yes. I had to go through those judgments because I know where your lordship are leading to. That's the reason I came prepared on those points also.
Yes.
Well, after the division bench of this court have given liberty for fresh adjudication relating to the cancellation of the quarter in favor of the petitioner, it was again taken up by the committee and the order was passed on 5/7/2002. That is under Annex 20, page 119.
That was shown.
Yes.
And that was implemented by the collector. That is the Annex 21. That is page 121.
Yes.
Against which, my lord, they have preferred appeal before the learning decisions.
Yeah, that order you have shown us.
From the order. Challenging that, my lord, they have again prepared a petition before this assembly. This honorable court have held that some documents of the petitioner has not taken into consideration. That's why it was remanded the matter. After remand, the committee again hold that he is not an industrial worker, and the cancellation order, which was passed in 2002,
5/7/2002.
that was confirmed. After it was confirmed, they have preferred the present writ petition against which matter this writ appeal is. The question that how the petitioner have been held to be in possession of the tenement in 1985, it relates to a document by virtue of an inquiry of the department, that is matter annexed, I have annexed in my counter. In the year 1989, there was an inquiry, and in the inquiry it was found that the opposite party number 5 is in possession of the property, and also there was a finding that he is possessing that property since 1985 as a subtenant under the petitioner.
Where is that report?
That, my lord, your lordship, my counter, they have not annexed that. They have
Do you have that report with you?
That in the counter I have filed. In the writ petition.
In the WP it is there?
Yes.
That is, go to the counter in the WP. That is a rejoinder affidavit of OP5. No.
Counter.
This is page 116.
I have filed the counter as opposite party number.
Counter. Yes.
Your lordship will kindly my counter page 13, my lord. Annexure A/5.
A/5?
5.
A/5?
My lord. Page 13 A/5. You also got it, my lord.
I got, but very difficult to read this. You only have to read it.
I will read, my lord.
Yeah.
On the above mentioned subject,
Who says this to whom?
that was sent to Assistant Labor Officer R.K. Behera, Assistant Labor Officer Cuttack, by
ALC.
AHC means
ALC.
Assistant Labor Commissioner.
Labor Commissioner. Your Lordship will get on. May I read, ma'am?
Yes.
On above mentioned subject, you are requested to cause an
Perhaps others may not wait. Now it will go on for some more time. It will take. Only about 3-4 persons who are in the line. Kindly be seated. Rest of the people are entitled to sit. Yeah.
On the above mentioned subject, you are requested to cause an inquiry on the spot in respect of the aforesaid tenement. Tenement is, my lord, give a verification. Tenements Z/4. Lordship will kindly subject.
Correct.
Report regarding the name of the present occupant, date of occupation of the quarter, and the name of the erst the present occupant working in which within 7 days. In response to the said letter, annexure B/5, your Lordship will kindly see.
As per your direction,
Letter so and so, I have verified the said tenement at Navga Level Colony where Sri B.C. Sutar has been staying since January 85.
How he will stay in January, from January 1985, when his very application was of 1980?
No, application. My lord, because the petitioner has sublet the house to the opposite partner of 5, he is occupying after the layoff, 84. He has left for the village and giving that quarter to the opposite partner of 5.
Where is that?
That I will show to your Lordship. Your Lordship can kindly see what is the occasion. To find out who is in possession because of the inquiry. Because of an inquiry, it was found that
by the authorities
that the opposite party number 5 is in possession over the tenement. Therefore, my lord, he was requested to make an application. Because he was an industrial worker, that also been given, my lord.
He was working in which industry?
My lord, that is there. He is working on Orissa instrument. He is a carpenter in Messrs. Orissa company, instrument company.
Yes.
Thereafter, my lord, your Lordship will kindly turn to.
What is annexure C5?
C5 was asked to deposit the
money and you have deposited.
At present, total remuneration is so and so month. See, BC Sutar, Bormali Sutar, up to village so and so, so and so. They will, because the total remuneration is 600. He was permitted to deposit, my lord. And thereafter, my lord, your Lordship will kindly see my application for settlement of the quarter Your Lordship will kindly see D/5.
What is this?
The allotment of the industrial tenement, it was passed on 5/1/90. Cuttack in favor of Bhaskar route of so and so, little so and so. Sir, hereby cancelled with immediate effect as per the section 8 of the so and so. For
yes,
in lieu of the conditions laid down, serial number 2. Your Lordship, of the serial note of the condition laid down in form allot so and so. That serial number 2 is my lord subletting. Your lordship, that the allotment order they have annexed. That is one of the that he is subletting the quarter in favor of the opposite party number 5, who was in possession of the tenement since 1980. And your lordship will kindly turn to in the writ appeal, page 84, madam.
Yes.
And my lord, these all the facts was taken into consideration by the Lord and Shigil judge while dealing with the matter. Now I will show to your lordship the benefit flows from that resolution, how he is not entitled to. I will show to your lordship, they have filed only one document. Your lordship kindly turn to page 75.
75. Of
This was an appeal. Page 74. Page 74 is the industrial law award.
Award.
Yes, my lord.
And 75 is the payment voucher.
74. So we kindly see 74 paragraph 3.
What?
The on challenge.
The expert hearing was so. From the unchallenged testimony, it has been brought out that the management has illegally
resorted to lay off. The workman raised industrial dispute. The Honorable Industrial Tribunal passed award on such and such in ID case number such and such.
Sanctions that the workman is entitled to benefit
as illegal and ordered. The workmen are entitled to get bonus at the rate of 8.33%.
The management has not paid the amount from 1784 to 31/3/1987
in respect of wages
and bonus. And it was calculated. Therefore, he has got the wages and bonus till 31/3/1987.
31,387.
Yes.
1784 to 87.
31,387.
Layout to 84.
Not paid the amount from 1784 to 31,387. Not paid it is. Paid nahi.
Has not paid.
Has not paid. Not paid. Therefore, even if your lordship will consider that he is an industrial worker, it will come till 31/3/1987. And no document was filed since 95 till today before any of the court or authority, which they have now introduced in additional evidence.
To show that he is an industrial worker.
Yes. Since 95 till today, those documents has never seen the light of the day.
Which is the cutoff date for allotment?
That is my cutoff date for giving benefit. When that resolution has come, resolution giving settlement of the tenement in favor of the industrial worker, it comes
in 87.
87, but July 87.
July 87. Relevant date is July 1987.
1987.
Where is that?
Yes, my lord, I am showing to your lordship. That is at annexure 11, page 81. And not July, that is June 24.
June 1987.
1987.
What it says?
Well,
Who
your
is
lordship-
eligible?
Your lordship will kindly see the serial number 3. After careful consideration, I have been pleased to decide to transfer the ownership of the tenement free of cost to the eligible and bona fide occupants subject to the following terms and conditions. The ownership of the tenement shall be transferred to the industrial laborers free of cost, subject to payment of all outstanding area rent by the occupant. Such ownership of the tenement will be transferred even.
Shall be transferred.
My lord?
Shall be transferred.
Such ownership of tenement will be transferred even to those who are industrial laborers at the time of original allotment but have subsequently been promoted in the same or any other industrial organization.
This is to be the industrial labor. But industrial, as on the date, industrial relationship of the status of industrial labor has to be put forth.
No. It is only relating to the possession. Even if he is not an industrial worker, yes.
Only to industrial worker.
Your lordship will kindly see.
The ownership of the tenement shall be
Subclause 4, your lordship will kindly see.
to the industrial laborer free of cost, subject to payment of all outstanding area rent by the occupants. If an eligible industrial worker has retired from active service, his case will be considered for transfer of ownership by the committee on merit.
So clause 1, there is a thing that such
ownership
a person shall be continuous possession of the tenement allotted to him. It is only relating to the possession.
Where you are reading that?
Your lordship, clause 1, category of permitted to
Page?
Page 81.
No, 81, but object.
3 clause 1. 3 clause 1.
This is
Lordship will kindly
industrial
see.
subsidized housing scheme for industrial workers.
Yes.
So how can it be other than the industrial
Your
worker?
lordship will kindly, I will read out the clause 3, my lord. Your lordship will kindly.
3.
Yes.
Government
The government, after careful consideration, have been pleased to decide to transfer the ownership of the tenement free of cost to eligible and bona fide occupants, subject to the following terms and conditions. Occupants.
Your contention is your client was occupied with effect from 1985. Therefore, he fits into this description. That's your contention. And he is an industrial worker also.
Yes. At the time of this
Resolution was promulgated.
at that time he was an industrial worker. He has not ceased to be industrial worker.
Where is that material?
It is there.
To show that he is industrial.
Yes. I will show. Your lordship will kindly turn to page 120. Page 120, the decision of 2002, paragraph 2.
After properly
service of the cancellation order on Sri Rao, the quarters so and so at the said Kapuria colony shall be re-allotted to Vishnu Chana Sutar, an employee of Odisha Instrument Company, Industrial Estate, Kotak, who shall be instructed to deposit unpaid.
Yes.
Now, my lord, the learned signatures has touched each and every point. So far that the letter I have shown to your lordship of the year 89 that there was an inquiry, and on inquiry it was found that the petitioner is not in possession and the respondent number 5 is in possession of the land. that was never challenged by the petitioner in any forum.
The Assistant Labor Commissioner's communication.
Report of ALO on the basis of the letter of ALC.
Yes.
Well, the next thing, my lord, is that even if this honorable court will accept that he was an industrial worker, then it should be 1/4/1987.
1/4/1987.
As per the which I have shown to you, lordship.
That observation in the award.
It cannot go beyond that. And the resolution was come on June 1987.
24 June 1987.
My lord.
It is the effect from July.
July 87.
6th July. 6th of July 1987.
Though it is dated 24/6.
No, that is the resolution. It will give effect. The resolution will come into force from the date of publication in the official Orissa Gazette. That is the mandate of the resolution.
6th of July.
6th of July, my lord. That is the resolution.
And the finding of fact that he is not an industrial worker, the finding of fact that he is not in possession over the tenement while the resolution has stayed, is concurrent finding by the tenement committee as well as by the learning single judge. My lord. Therefore, my lord, in the writ appeal, my lord, what is the, my lord, scope to interfere with the order of the single judge? Lordship knows that.
You may assume that.
Can I clarify something? There are 3 to 4 points I have taken note of to be referred to verify. Lord, first of all, your lordship would see with regard to the appeal part. Lordship, may kindly see the annexure 2 that the committee report.
Can we request you to give short synopsis?
Lord, I'll give it 2-3 minutes.
Yes.
No, I understand 4 o'clock.
No problem.
But only 2 minutes. Kindly see that order. The appeal stage has not come. Submission that was made that I should appeal, it's not correct. Kindly see that order passed by the housing committee.
That will not fit into section 8.
No. The cancellation of my allotment order has not yet surfaced. After the committee order, we had annexure 2, that is page 64. Kindly see annexure 2, page 67. Kindly see, my lord. The nature of the order, kindly see, my lord. Last paragraph. In view of the above, it is resolved that collector cum housing commissioner Cuttack shall take appropriate action as per so and so Housing Act 1966.
Orissa Industrial Housing Rules 1969.
And resolution. The submission that was made that 87 is never the scope of consideration is absolutely incorrect. The 87 is
spoken of here.
Yes, the submission that was made that your lordship asked whether that will report to anywhere. The answer was no. It is incorrect submission. Kindly see page 67.
As on 14/12/2020, that has been referred to.
Yes, ma'am.
14/12/2020.
Also referred to, ma'am. Then kindly see the last 3 lines. To evict and cancel the allotment of so and so in favor of Bhaskar Rao. But as on date, the cancellation has not surfaced. So it is only the question of
Direction to cancel.
direction to cancel, and cancellation has not yet surfaced. Now it is only the question to be considered here, Your Lordship, with regard to my right of allotment. Kindly see, our prayer is also at page 158 is only for allotment, not for cancellation.
Settlement.
Now, Your Lordship, may kindly see the second
By way of settlement.
Settlement.
page 158. Now, the second point that was raised, my lord, with regard to occupant, Lord, very emphatically submitted that since I am in possession, I am entitled to settlement. Lord, with great respect, if Your Lordship see again, I have shown it to Your Lordship, kindly see section 6, Lord. Merely because you are an occupant.
Unless allotment is granted.
Now, what is the date of your allotment? Kindly see the allotment, my lord. That is 24/6/1990. Even as on the day when the resolution comes, you are not an allotee. Kindly see, my lord, that order. That is at page. Allotment page to you.
86.
Page 86, man. But these are all admitted positions. It can't be disputed. Kindly see, my lord, page 86. 26/4/1990 is your allotment. Even as on the day resolution comes into force in 1987, your allotment is 1990.
Yes.
But am I clear to this effect, man? Now, Your Lordship, one more aspect, my lords may kindly see. Kindly see the explanation to section 6. A person shall not, merely by reason of the fact that he has paid any amount as rent, be deemed to have entered into possession of the house as allottee.
Mere payment is not proof of.
Lord, the provision itself says this. Lord, my third point, Your Lordship, would kindly see. Lord, that order of the learned the commission, what has been considered by the Honorable Singh Governor Das Bhanji, my Lord, Your Lordship, well about that. The commission says only my entitlement, whether I am an industrial worker or not. Now, Your Lordship may see that the submission was made that as on 1/4/87 I cease to be an industrial worker is factually incorrect. But I have cited the certified copy public order judgment passed by the Industrial Tribunal, which are not disputed as on date before my Lord's speech. Kindly see, this is judgment passed by the Industrial Tribunal and certified copies, my Lord. That says, page 12.
It said, layoff dated 16/8/1984 is held to be illegal.
Lord,
therefore, all consequential benefits you will have.
Then the next day, the submission was made that I was paid bonus up to 1/4/87 is factually incorrect.
No, we are asking you simple one question. Whether layoff will put an end to the vinculum juris of workman-employer.
Lord, that is subject to a dispute. Layoff amounts to retrenchment of the workman.
Yeah. Layoff amounts to retrenchment.
Yes, retrenchment of the workman.
If it is set aside, then
Same.
reinstated.
Because 25F is also
applicable. As if it is a I'm not good in labor law. Never I practiced on labor.
So grateful, Lord. Kindly just see this one page, Lord. I'll request Your Lordship to take little.
But that speaks about the payment.
Payments, various amount, 20,000 odd, etc.
Lord, from 1/4/87 to 31/10/2005. So the submission that was made that it stops at one.
That you showed that time in the table.
In the table, yes.
That is up to 1995.
That
2005.
That was for part of my claim. Subsequent part is under this award, 33C2. Say subsequent award. Serial number 4, 1/4/87 to 31/10/2005.
So that document, whether your lordship will take it into consideration?
Let us see. You have said that also. We have noted it.
Yes, my lord. Since 1995 till today, those document has never seen the day.
This 33C2 document has never come.
No.
Lord, this is a certified copy of the judgment.
No.
It has a, Lord, this can be referred to on section 51 of the Evidence Act. It's a judgment passed by the tribunal. So therefore, unless you are disputing this judgment is not there. Lord, matter is different. So Lord, the next point that was raised, and Labour Commissioner has also passed an order to implement that award.
After disposal of the
writ petition, 8/7/2025. That is also part of that IAF.
That is 29, section 29 order.
Exactly, Lord, section 29. To implement that award. Lord, the submission, Lord, with regard to point of law only, I'll just take your lordship to that Industrial Housing Act, not only one provision also and stop there. No? Kindly see the submission that was made that the only occupation is the criteria for settlement is absolutely not correct. Kindly see again that resolution. Lord. Kindly see page 81. Lord.
87 resolution.
87 resolution. Occupation is not the criteria for allotment, settlement. Allotment is one of the criteria coupled with occupation. Kindly see, man. We can't skip the word allotment.
Occupation of an industrial worker.
As
an allotee.
Yes. But kindly see, I am reading it. And I am reading it. Ownership of the tenement shall be transferred to industrial laborer free of cost, subject to payment of all outstanding arrears rent by the occupants. Roman 1. Such ownership of tenements will be transferred even to those who were industrial laborers at the time of...
But subsequently promoted, and therefore that status they will not have, even they will be treated to be occupants.
But kindly see, to be continuous possession of the tenement allotted to him. So
allotment is the requirement of that entire
resolution. That is what I wanted to highlight. So merely because you are in somehow or other you are coming into claiming possession, it can't match your right now.
No. I am answering to the submission made by my Lord and brother. It is not the case that allotment has been made in favor of the respondent number 5. The petition issue is not there. There is no issue for allotting the quarter in favor of the respondent number 5. The issue, your Lordship will kindly see the order of the Tenement Committee and the order of the London Single Judge, whether he is entitled and he is an industrial worker, that has been decided, not, my Lord, in relation to the respondent number 5.
Yeah. Take this. If this is heard result,
great.
Let us.
But if you want us to
continue, till punishment of judgment. No.
Should I file a small note?
It appears that will be handy to us.
I should.
Within one day.
This opportunity of addressing